Everyone, welcome to the Thursday, December 17th, 2020 meeting of the Planning Commission. If you wish to join us, you have options to join us via phone or Zoom. Go to the county website and you can see the different options there, and it'll explain how you can join us. And I need to read the note. In accordance with Executive Order N29-20, the Planning Commission meeting is being held virtually.
Yeah.
Yes.
You've got multiple people on the screen right now, 5 people. Now you're 6. I just switched that.
Oh, okay. Thank you. Yeah. Sorry about that. I don't know what I did, but sorry about it. So with that, I will call the meeting to order, and I would ask you to join me in a salute to the flag.
I pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, indivisible, with liberty and justice for all.
Thank you. I would ask Laura to do a roll call or commissioners present.
Alan Bongio.
Present.
Ronnie Pellegrini.
Here.
Noah Levy.
Here.
Mike Newman. Mike Newman. Peggy O'Neill. Peggy O'Neill. Brian Mitchell. Brian Mitchell. Melanie McAver.
Here.
Thank you, Laura. Maybe a few of them will join in with us shortly. Yeah, we have 4. We have enough to have a meeting. So, will there be any agenda modifications? Director?
We have no modifications to the agenda. We do have several supplementals. We have supplemental for 30 Deep. We have a supplemental for Emerald Coast Genetics, which is requesting a continuance to January 7th. We have a supplemental for Organic Medicinals, which is requesting a continuance to January 21st. We have a supplemental for Ancient Truth, item E8. Actually, there's two. Well, I had the same copy there. We have a supplemental for the amendments to the Humboldt Bay Area Plan, and that would be it.
Okay. I wasn't quite quick enough to get all those, so as we're going through, tell me when if one's being continued, please. Thank you. So with that, I think we are at the point where we have public comment for any item that is not on the agenda tonight. So I will now open that up and get over to attendees.
I'm sorry to interrupt if I am, but I can't really hear you, Alan.
Okay.
I was in the same boat, Melanie.
Oh, okay. Yeah, I wasn't sure if it was my end or not.
Let me see if I can turn my volume up. I'm maxed out 100%, so I don't know what.
And Chairman,
get closer. Yes.
Chairman, I am here in the house now. I got on by going into the conventional way on Zoom.
Thank you, Mike, for letting us know. I'm not sure. Do you have any ideas?
Alan, if I can just suggest, it's not so much soft as kind of muffled. So I don't know if that helps at all. Is there something in between you and your I don't know.
No, I don't know what I'm doing different than I did at every meeting, to be honest.
Maybe the mustache has gotten a little longer.
Yeah, that's it. That's it. A little grayer, if nothing else. You got the.
Yeah, it definitely sounds like it's the computer and not you.
Is that any better? He made some changes.
Yes.
That is better. Yeah.
That's what we have these people that are amazing for. Thank you, Josh. All right. So with that, I am going to open up the public comment. It looks like we have one hand up. Go ahead, Kent.
Ken Swatsky here. Yeah, I was going to make the mustache comment, and then Noah stole it from me, so I'm a little irritated with that one. I have some really good news for anybody in the cannabis business. You can apparently use the County of Humboldt logo in your branding. It was pointed out to me before that Honeydew Farms was using the county logo, and so everybody, I guess, should be able to use it. Personally, I think the county should be reimbursed for that logo's use. I also have reservations because, in my opinion, using that logo is an implied warranty on the product that's out there. And so far as it's being represented, it's been approved by Humboldt County, the County of Humboldt. In other words, just not that it's in Humboldt County. But that's an interesting one. Hopefully that will be closed. My opinion, there's probably been millions of dollars worth of revenue lost because of not being able to use, because of that being able to be used without proper compensation. But we'll see where that goes. Enjoy it while you can. I have been speaking with some people on regarding water, and I had a few environmentalists on the phone today, and apparently you don't allow bladders, but these people seem to think and agreed with me, as far as I'm not mentioning names, that basically bladders, if used in a proper manner, can be an exceptional way of storing water inexpensively. And I would encourage the county maybe to have a pre-permitting process with the design where these basically are contained within an earthen dam, and others push right up against it. I think that probably makes sense to Mr. Bongio and myself. So you have a little bit of strength there. We're getting a lot of feedback. Anyway, I'll continue. So anyway, this is a concept I really think you guys should check into. I have a lot of angst regarding all this water being pulled out of wells during seasons. And then again, further conversation with staff was that you have something where if we have a drought, those people are allowed to truck water in to keep their crops alive. But where are they going to get the water that's not going to have even more of a negative impact during drought? So I think your basic storage of water needs to be dealt with here sometime, hopefully staff, and you can arrange to bring that topic forward. And so we're not going to be stealing water out of all the watersheds when it's least appropriate to take, which would have to happen during the main prepared season, most likely. That's when it's needed and their wells would go dry. So that's a recommendation coming from the public. And a little bit from, since you're messing with Mother Nature, why don't you minimize your impact? That's my comment. So thank you for my opportunity to speak on those two topics today.
Thank you, Kent. The next speaker is Public 3053.
Good evening, Thomas Mulder here. I want to confirm you can hear me.
Yes, Thomas, welcome.
Okay. First off, I want to start by thanking the staff, the Planning Commission, and the Board of Supervisors for not getting one, but two ordinances passed through that have met CEQA guidelines. If you kind of look at the headlines of our neighbors bordering us, they're kind of having some CEQA issues right now, and a lot of people are stressed out. So I know there's a lot of flack from environmental people, community people in the industry, lots of different things, but I have to be thankful that we have two ordinances that meet CEQA guidelines, and I think that's a great representation on staff and the Planning Commission and Board of Supervisors and the community. With that being said, I would like to possibly see some radical policy changes. I'm seeing in a community, the community is a lot stronger when people are able to reside and earn a living and live in that area. So maybe there's a way to bring these homestead farms back in. You guys did the small ordinance adoption, but maybe there's another way that projects that have been abated after they've lived there for 5 years, maybe they can get a permit for 5,000 square feet. Just an idea, some sort of incentive program being only if they reside on the property. Just some different things I'm seeing whenever people are able to pick up these 40-acre parcels of land and clean them up from the previous landowners and really remediate them, but also let's think about home ownership and their ability to still live in the community and be active people within the community. I think that'd be important. As far as Ken's comment about water bladders, my understanding, and I could be wrong, and it's DFW that really doesn't like the water bladders in case of a catastrophic failure, downstream potential sediment. So a lot of the things the county gets slack for, a lot of times it's DFW actually putting the wrenches to things. Also, there is a water solutions. I can't remember the name of the company, but there's a rainwater catchment company in Garberville that harvests water via rain catchment and provides water to people in the community down here in southern Humboldt in the dry months. Maybe there could be more things like that allowed within the county to offset those environmental concerns from people. Thank you for the opportunity to speak.
Thank you, Thomas. Any other speakers that would like to speak on public comment? Seeing none, I will close the public comment.
There's a bad echo there with you, Alan. Alan, you were on mute there, so whatever you said did not get heard.
So we'll try that. It didn't seem to be better. I'm not sure what's different than it has ever been.
Harry, I think you fixed it.
Right.
You didn't do anything.
Well, I just turned my volume way down.
Okay.
Your sensitivity was up. Yeah. It didn't look like anybody else was.
All right. Well, we'll keep trying. The director turned his sensitivity down, I guess, so maybe that'll help.
Yeah, I think it's always tricky when you've got multiple speakers in the same room. So.
All right. Well, we'll see if this works. Okay, so the next, I'm going to go through the consent agenda, and if there are any items that either the public or anybody on the commission would like pulled, please raise your hand and we will take that off the consent agenda. So the first item on consent is, and it's pretty long tonight, so quite a few issues. There's already a hand up, but we haven't even asked a question yet. So, the first one is Alderpoint Road Farms LLC conditional use permit. Does anybody wish to have that removed from the consent agenda? Anybody on the commission? I see a hand up, so that will be pulled. Item number 2 is 30 Deep LLC conditional use permit. I see a hand up. That one will be pulled. Item number 3, Reed Mountain Farms Cooperative Incorporated conditional use permit, special permit. Anyone on this one? No, there's a hand, so that will be pulled. A couple hands. Item number 4, WC Grace LLC conditional use permit in the Willow Creek area. Anybody care to have that item pulled? Seeing one hand, we will pull that item. Item number 5, Kalanola Incorporated conditional use permit in the Neeland area. Anybody care to have this one pulled? I see a hand. That was pulled. Item number 6. This was one of the ones I believe that was asked to be continued, so we'll be in, that was, okay. We'll do that. No, item number 7, Organic Medicinals Incorporated Special Permit and zoning clearance certificates in the Shively Flat Road. This one has also been pulled and continued. And we'll deal with it individually as well, okay? Next item is number 8, Ancient Truth Incorporated Conditional Use Permit in the Bridgeville area. Anybody care to have this item pulled? Hand up. It looks like we're going to have a consent agenda tonight. So with that, that was all the items on the consent agenda. So we will now just go through the items as if they were a regular agenda item. And the first one, we'll take a staff report on, well, actually, we got pulled, the Alderpoint. Do we want to continue it to us? This one. Oh, public hearing. I'm sorry. You're right. I had this the next one that I was thinking of. This was pulled, so we will take a staff report, please.
Hello, I just want to confirm everybody can hear me. I'm David Mack, contract planner with Harrison Associates, and can you see my screen? Great.
Yes.
Okay, so the item before you today is Alderpoint Road Farms, PLN 010818. Hold on just a minute. It's located in the Blockburg area at 35082 Alderpoint Road. The APN is 217-031-001. The zoning is unclassified and the existing land use is agricultural grazing, 40-acre minimum. In this particular case, the parcel is 75.38 acres, so it does meet the minimum. The scope of work is a conditional use permit. The applicant is requesting to permit the maximum amount allowed under the CMMLUO and the cultivation area verification of 60,360 square feet, broken down into 1 acre of outdoor cultivation, 43,560 square feet, and 16,800 square feet of indoor or mixed light cultivation. In this particular case, the irrigation will come from 3 sources: an on-site rain catchment pond, an on-site well, which has been permitted, and the diversion of an existing spring. There are 2 power sources, the first being PG&E, and then 2 supplemental on-site generators of 165 and 200 kilowatts. The site plan that is included in the application, dated October of 2020, is for a little bit less than the maximum, but the applicant is requesting the maximum so they can grow into that allowance. However, the site plan is for a total of 47,172 square feet, broken into about 32,000 square feet of outdoor cultivation and about 15,540 square feet of mixed light cultivation. In total, there are 3 separate growing zones, and I will have a slide showing those momentarily. But zone 1 is just under 19,000 square feet. Zone 2 is just over 18,000 square feet, and zone 3 is about 9,500 square feet, give or take some adjustments. There's also a nursery or immature plant area, which will consist of 3 greenhouses for a total of 4,800 square feet. And the slide before you shows the 3 proposed growing zones, again, broken down into square footage on the site, and the nursery or immature plant area being to the north of those proposed areas. Each of these 3 zones does does contain greenhouses as well as outdoor potted plant grows. A addendum to the mitigated neg deck was prepared, pursuant to section 15164 in October of 2020. The addendum did not identify any substantial impacts or effects that would result from the project, since it is consistent with all ordinances, and there was no information submitted on the record to demonstrate otherwise. Staff is recommending that the Planning Commission adopt a resolution to approve the use permit to allow a maximum cultivation area of 60,360 square feet, and which is supported by the findings and evidence and subject to the recommended conditions of approval. And I would be happy to answer any questions the commission or the public has on this item.
Are there any questions from the commission or staff? I'm sorry, I should say. Seeing none, unless I'm missing it, I would. I don't see any, so I will now open this up to the public for any public comment on this. We have one hand up. Go ahead, Kent. Go ahead, Kent. Unmute yourself.
Okay, took 2 tries on the unmute, but I got there, sorry. I just want everybody to know I was not the first responder pulling all these off the agenda. Some of them I did pull, but I would have pulled them all. They all have things that I think should be addressed. I would wish and hope that the applicant would take a friendly amendment that basically since the power is being provided by PG&E, they enter into that more friendly agreement, the thing that supports the environment a little bit more. I think they have can't remember, John Ford can tell you what that is. I also did notice, as far as you have a diversion from an existing spring, an on-site well, and you have existing water storage of 692,000 gallons, 400,000 being in a pond. But even without that pond being considered, I believe my math shows 292,000 gallons that could be stored in the hard storage they have there. And I just would like to see, getting away from diversions from an existing spring and from a well, and to use catchment or whatever you can for all of these things, as was mentioned by hopefully someday Supervisor Mulder there, that there are alternatives to this particular stuff. I also do wished that you put some kind of constraint on the pond, that it's been brought forward by myself and other people, the possibility of the bullfrog infestation, and I guess that you'd have to require that pond either be contained, as I spoke earlier, in a bladder, or else it be drained during the time to prevent bullfrog. That was something that in the zoning administrator meeting was volunteered to be done by a guy who kept it there long enough for the duck to be there, and then afterwards he drained the pond so he wouldn't have the bullfrog farm. I also have a question regarding the nursery, and I have been under the perception that some of these nurseries are being used, and maybe this one is. Maybe it's included as 60,360 square feet, but if you can take those plants right up to ready to be flowering, I don't know what your cutoff is for a nursery there, but sometimes I've had the feeling that that's additional grow area, and so I do question how that is being used in a permit, possibly to circumvent the cap on the size. Maybe the applicant's representative can assure me that does fall within the 60,360 square feet and is not just an add-on for addition beyond it. Of course, this project is taken to the max, as we're all aware, possibly following all guidelines. So those are my main concerns on this particular project, and hopefully those will be addressed by the applicant's representative or staff.
Thank you, Kent. Anybody else? Any other public comments on this? 3053. Go ahead. Thomas Mayer.
Good evening, Thomas Mulder. I'm just going to talk in perspective. I have not read the staff report. I just listened to the staff presentation of it. I just have to remind everyone, it sounds like this is the ordinance 1.0 as well, that generator use is allowed. I mean, we don't love it, but that was the ordinance to bring people forward. I think if we start imposing these different rules upon projects to back off of generators, there needs to be a tax incentive. And I think that needs to be brought forward by the Board of Supervisors. So that way there's a tax incentive for people to get off those fossil fuels. I can speak personally. I know PG&E is a long process. I'm 3 years into it, probably 12 more months out before anything happens due to COVID, fires, all kinds of other unrelated issues that were out of my control. And that's the reality of it. I personally would love to be off of, generators, but that's the way it is. So I just want you to remember that when you're trying to add these additional conditions of approval, that it's technically outside of the ordinance, and the ordinance was written to bring people forward. Also, when you add extra conditions of approval, that also puts another workload on staff, and there needs to be money tied to have that staff to follow through on those things. Thank you for the opportunity to speak.
Thank you, Thomas. Any other speakers on this? Would the applicant like to speak or can answer any of those questions or any thoughts? Seeing none, I will bring this back to the commission for discussion. Any thoughts, any questions? Director, did you have something to say? You lit up.
Well, I think one of the things that we probably do want to respond to is that the diversions are allowed under 1.0 for existing cultivation. They do need to forbear. That is a component of the permit. There is water storage associated with that. Existing ponds typically have not been necessarily retrofitted for bullfrog management. And the nursery is not included within the 60,000 square feet. We typically have tried to keep it about 10,000 or 10% of the total cultivation area.
Ronnie, I see you have your hand up.
Yeah, only one question. In the staff report on page 5, it talked about a remediation / abatement of prior violations of a fine of $88,000. And just my question is, has that been paid? Because that was a requirement for receiving the permits. And that's pretty much it.
I'll respond to that. So we typically do not bring these forward to be at the commission hearing until that is resolved.
It would be a question, sorry.
Thank you. Anybody else have any questions? Anybody care to make a motion on this?
I will move.
Brian, go ahead.
Oh, okay.
Oh, Brian has hand up. I'm sorry, Noah.
No. Brian had his hand up. We should go.
Oh, thank you, Mr. Chairman. Thank you, Noah. I guess I just wanted to circle back to a couple of the public comments. With regards to the electricity use, I think that asking the applicant to opt into the environmentally friendly, carbon emission reduced portion of the PG&E power is a reasonable request, because I don't think there is a substantial or negligible cost differential and can help offset the carbon emission impacts from projects like this. I also wanted to say that because there are a couple of backup generators, I was hoping that we could add a condition of approval that would have staff look at the hobs or the hour meters on the generators, just to ensure that those generators are in fact only being used in emergency or power outage situations. And I would like to hear staff's input on how CDFW typically would ask us to mitigate the bullfrog mitigation for an open pond like this. It seems like storage bags or tanks or something else would be potentially a better fit. But without extending the cost too much, potentially there's mitigation so we can just keep it from becoming unwanted habitat for these types of unwanted species. Other than that, I'm prepared to support the project.
Director, do you want to?
Yeah, so in terms of the bullfrog mitigation for new ponds, and this really came about during the Odessa project that was out in beyond Maple Creek. What was requested at that time was to put a amphibian-proof fence around the pond, in addition to putting a wildlife-proof fence around the pond to keep both wildlife and amphibians out of the pond.
There's some other questions.
Well, I'm not sure if they were questions or requests, but in terms of, you know, the green power using a renewable power source, that is definitely a requirement of 2.0 that was not addressed in 1.0. This is a conditional use permit, so the commission's not necessarily limited to imposing that condition, but that was not part of the policy direction of 1.0. In terms of backup generators, certainly a condition to review the meters and look at the operational logs for the generators during the annual inspection is something that can be done.
Thank you, Director. Any other questions?
Just to clarify, Mr. Chairman, I intended those to be requests for additional conditions of approval.
Would you like to make a motion with those conditions added? Director Bush? No? Okay. Noah, you had a comment back when Brian spoke up, so.
I did. I think I was prepared to make a motion. I still am. I guess I have some hesitation about, I mean, it's one thing to limit generators. You know, I join with Thomas Mulder in some of his remarks earlier in reminding us that though we don't like it, some generators are allowed, but for a PG&E project to require them to do the extra carbon friendly, I mean, look, I do it at home, but not because I have to. You know, I'm not sure that should be a requirement when so many other businesses are not required to do that. All that being said, so I guess I'm not sure if I'm ready to move with that requirement or not. I just wanted to maybe have a little discussion on that point.
Anybody else?
I'm sure I'll chime in on that.
Mike?
So by having the logs for the generator added as a conditional use, what would be the benchmark that we would be looking towards?
So I will take a shot at the answer to that. I think the thing that we'd be looking at is to see if the generator was being run a minimal amount of time to allow for maintenance on the generator, to keep it running, make sure it's running, make sure it comes on, and then for the occasional power outages that occur. We'd be looking to see that the generator hasn't been running for thousands of hours. You know, we wouldn't be quibbling about a few hours here and there, but really be looking to see if it had been running for weeks, months.
Is there a benchmark hours that we would be looking at?
This is a brand new one. I've not thought about this before, so I cannot give you a specific answer in terms of number of hours. I'd be pulling something completely out of the air.
All right. Melanie, I see you have your hand up.
Yeah, I just wanted to add my comments to the discussion. So one of the reasons why I proposed that we ask the director for an incentive the last time we discussed this is because I really think that it could be fairly argued that this would be a significant change from the original documents under CEQA. And I don't feel comfortable adding on things that I don't think really within regulations we'd even be allowed to do, aside from the whole issue of it being fair to people who didn't know that what was the case years ago when they started their applications. And so likewise, I don't really feel comfortable adding on something for, you know, the selection of the, I guess, less emissive program under PG&E. You know, these are things that I would have maybe liked to have seen in the original, but and I'm fine with what we've been doing, which is kind of on a case-by-case basis when it really seems to warrant those conditions. But I'm not convinced that this one does, and I don't feel comfortable having a, you know, blanket policy that I don't think we'd really be allowed to have anyway. That's all.
Melanie, any other commissioners have questions?
I guess I just wanted to argue the point, Mr. Chairman, was that in looking at the rate sheet that RCEA puts out there, you know, they do a great job trying to provide, you know, alternatives that aren't substantially more costly than their other rate tiers. And it's not that it's the exact same price, it's that they do their best to make sure that they're comparable. And in this particular project, where they have a certain amount of square footage that they can prove that they've historically grown, and then they're asking for an additional 10% of that for the propagation area, they are asking for the absolute maximum that they can ask for. And because of that, I feel like it is appropriate and logical for us to ask for them in turn to make the choice that will have the least impacts on the environment vis-a-vis carbon dioxide emissions.
I just want to respond and say, you know, I appreciate Commissioner Mitchell's logic about this operator sort of extracting the full rights, and therefore we should, you know, I would support it in this case. Like Commissioner McCaver said, I think we've been making case-by-case determinations on amending, adding certain conditions, but, you know, I just will restate that I definitely am wary of the notion of setting precedents where, you know, this would then be added by, you know, routinely added to as a requirement to every project. But I know that's not what Commissioner Mitchell is suggesting. So I would certainly support a motion to move this forward with that condition attached.
Any other discussion on this?
So,
go ahead, Mike.
So possibly about maybe logging the generator use and noting it so that we can see for future use how much is being used. Would there be anything that we can review down the road there, Mr. Ford?
Well, we can certainly review the use on an annual basis, and provided it stays at a
minimum,
at least on the appearance a reasonable level,
right.
We would treat it as being acceptable. If we saw that it was being used excessively, or if we got complaints about it being run when power is available, then we would deem that to be inconsistent with a conditional use permit.
Okay. Yeah, I personally would like to see some sort of logging of that in the motion. What my other question would be about the pond and the bullfrog thing. Just to bring him into compliance, that was not part of 1.0, is that correct?
That was not included within the mitigation measures, that's correct. But we often implement recommendations from CDFW where there's a concern about bullfrog infestation.
And there was none on this one?
I'm going to defer to either David or Cliff on that.
This is David Mack. From my review of the file and the comments submitted by CDFW, they did not submit any comments to that regard.
Okay, thank you.
So any other comments, or would somebody like to make a motion on this one? I'm going to try and keep this rolling because we have a lot of issues tonight.
Mr. Chairman, this is Brian, and unfortunately, I can't get the specific language to load. But if it pleases the commission, I would like to make a motion that we close the public hearing and approve item number 1 with the following 3 changes to the conditions in the staff report. Number 1, that we require appropriate bullfrog fencing surrounded the open air water storage pond. 2, that the generator logs and operations logs are reviewed to ascertain and prove that the generators are in fact only utilized on an emergency and infrequent basis. And number 3, that in light of the scale of the project, that we ask that the electricity that's purchased through RCEA and PG&E be the environmentally superior tier of electricity.
I'll second that.
So we have a motion and a second. Any discussion?
Could I ask a question?
Yes, go ahead, Director.
Commissioner Mitchell, I'm assuming that when you said because of the amount of square footage, you were identifying that we would add language into the findings as to why those conditions are being added.
Correct.
Thank you.
So we have a motion and a second. Any further discussion? Seeing none, I will ask Laura to ask the question.
Commissioner Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Yes.
Melanie McCaver,
Yes.
Thank you.
Oh, you're right. I just didn't hear. I'm sorry. Didn't hear her name. Well, the motion carries unanimously. Thank you. All right, moving on to the next item. 30 Deep LLC conditional use permit in the Alderpoint area. I would ask for a staff report.
Good evening. I'm going to see if I can get my...
Barely can hear you.
Oh, sorry. I'm going to see if I can get my screen to share. Is that working?
Yes.
Okay. Oh. Okay, well, I'm going to figure out getting my other screen up here. Okay. So I am going to give you a brief presentation on the 30 Deep LLC conditional use permit and special permit. For a little bit of backstory on this project, it was initially scheduled to be heard September 5th, 2019, so over a year ago. And at that time, at the applicant's request, it was continued to a date uncertain. After a little over a year, and despite some unresolved issues that will be discussed, the applicant requested that staff bring the project forward to you tonight. You did receive a substantial supplemental packet this evening pertaining to two separate issues. The first is that the applicant submitted a new site plan and operations plan. After receiving news from staff that we would not be recommending approval of these proposed changes, the applicant has withdrawn their request to have the project revised. So we do not need to give special treatment or attention this evening to those proposed changes. The second issue that is discussed in the supplemental packet is that of legal documentation pertaining to the access to the subject parcel. And it includes settlement agreements, several correspondences from attorneys, and this issue will be discussed this evening. So go to what is being proposed. The applicant requests a conditional use permit to continue an existing cultivation operation. It includes 28,668 square feet of outdoor cultivation and 4,110 square feet of mixed light cultivation. The water source is a deep groundwater well. There is on-site proposed processing, and there's also on-site ancillary nursery. The primary power source is a solar array. There is a backup generator. The special permit that is part of the request is for restoration activities that were performed in the streamside management area. This is the location of the project. For context, here is Alderpoint Road, and this is the community of Alderpoint. The zoning is agriculture exclusive and timber production zone. It's mostly TPZ, but there's a bit of AE, general plan, agricultural, grazing, and timberland. This is the site plan that is being considered this evening. These are the locations of the cultivation on the parcel. This one, this black square, that is the cultivation that was within an SMA setback. So the proposed relocation is basically to go to these two sites. All of the cultivation in these three is full-term outdoor in pots. This cultivation here is in greenhouses. This is the location of the approximately 4,000 square feet of mixed light. This is the ancillary nursery. This is a structure that has material storage and, sorry, I got an echo there. Material storage and also the proposed processing activities. This is the water infrastructure. The location of a well is here, and we have water storage at those 4 locations. It's also, I'd like to call your attention to the fact that the site it does have an SRA turnaround here, which satisfies fire safe, or part of fire safe. So now to go to the question of access and sort of the conflict that is at the heart of the project. A little bit of context. So in 2012, a previous owner of the subject parcel that currently has the proposed activities was unable to sell the property because it lacked an easement. Subsequently, they filed a lawsuit, and the outcome of the lawsuit was there being recorded 2 documents. One recorded document was the easement deed, another was a log hauling agreement. The source of the conflict is the easement deed, and the line I want to call your attention to is the line here that says the easement is hereby created for the benefit of a single family residence and uses incident thereto. It was scrutiny of this line that resulted in the project being continued last year. And at that time, staff directed the applicant to see if they could work with their neighbors to change the language of the easement. The neighbors were not interested in changing the language. And so we found ourselves in a position of needing to decide what the path forward would be for this project. We've received legal opinions and public comments from attorneys representing both the applicant and the neighbors. They're in disagreement about what was settled in 2012. While the language of the easement does seem clear, there is reason to believe that there's potential for commercial operations to be considered incident to a residence. There's also potentially the grounds for a prescriptive easement, given the length of time that operations have occurred on the parcel. These, however, are questions that are outside of the scope of county code and typically would be resolved through a legal agreement or potentially a lawsuit. So staff kept our findings based on the language and requirements of the zoning code. There is a requirement for all parcels to have legal access. However, there is no specification in the CMMLUO or elsewhere in the code as to the type of access required to carry out activities that are approvable for a given zone. So staff has all of the information needed to make the findings that the project comports with county code, the general plan, and CEQA. We did include an informational note in the staff report that would say approval of this permit does not specifically authorize the use of the existing access easement for any purposes for which the easement does not legally allow. And that is, us saying that if there is a resolution of this issue in another forum, that this entitlement would not be, granting or challenging that potential access. But because we can make all of the findings required by county code, the staff recommendation this evening is approval of the project. And I would be happy to respond to any questions that you may have.
Any questions of staff?
Chair, if I could clarify one thing.
Go ahead, Director.
I think I just want to clarify something that Mr. Hilton said, and that is there is no provision in the zoning ordinance requiring proof of legal access. There is no requirement in the zoning ordinance for legal access. And so, unfortunately, our regulations are quiet on this point. And that's why we come to the conclusion that we do, is that in order to do something beyond that, we would be requiring something of the applicant that our ordinances don't call for.
Go ahead, Ronnie. You have your hand up.
Yes, thank you, Mr. Chairman. I just find this one troubling in a couple of ways. First, I had a call in to our planner, Hilton, to try to get some clarification on this and didn't receive a call back today. So I'm bringing them up now in front of everybody. So what's troubling to me is the access. Nothing has changed since 2019 when it was kicked back. Nothing's changed. Nothing's been resolved. And yet we're asked to approve the permit, and the access hasn't been addressed. And I don't think it's fair to the burden of proof is on the applicant. Yet we're throwing the burden of proof on this innocent neighbor that's already gone to court on this issue. They feel like they've completed it, and I don't think the commission would allow a Costco to be built without establishing legal access. Or ask Alan, would a subdivision be allowed to be built without established access? I don't think so. Those are kind of troubling issues. And has this been, has the applicant been operating under an interim permit? And if so, when was it issued? Were those neighbors noticed? Because I think that's kind of an important issue to bring to us, because that's one of the criteria for prescriptive easement, which they're claiming now you have to be using it for 5 years. So if we keep stringing the commission along, then we can finally get an approval because we've met that threshold. I think some of these issues are kind of murky. Thank you.
Thank you, Ronnie. Mike Newman, you have your hand up.
Yes, I was going to ask where in the amendments are the recommendations for approval about the easement.
We would like, go ahead, Keenan, I guess.
I'm not sure I understand the question. What? I'm sorry.
In your presentation, you had said, Keenan, that it was part of the requirement in there about access. I can't remember exactly the words that you said, but that you had said that it was in the conditional recommendations for approval.
Oh yeah. So in the staff report, it's in the section Informational Notes, and so that comes after the conditions of approval and and the ongoing conditions.
All right, what page is that?
Let me find that real quick.
Look around page 18 or so.
It is on page 19.
Okay. And which number?
It is number 9.
Okay. Yeah, the approval of this permit does not specifically authorize the use of existing access easement for any purposes for which the easement does not legally allow. Okay, thank you.
Mm-hmm.
Any other questions from commissioners? Well, I have my hand up, so I have a question since you're claiming that this is a prescriptive easement, and does if this easement has been used to service this residence for years, you know, I'm not sure how many years exactly, it differs and everything. So, but let's just say they've been using it for more than the 5 years for one use. Now we go to using it for cannabis. Does the change in the use change the prescriptive easement? I don't know if I'm asking the question correctly. This might be for legal staff, but it seems like they're changing what it's been used for in the past.
So this is probably more of a question for legal staff, but I think what the letter that was submitted by the applicant's attorney, Russ Gans, was getting at relative to the nature of cannabis is that cannabis has been being cultivated on this site since before 2012. And I was skeptical about that. So I did look at aerial imagery, and if you'll give me a moment, I can probably go back and find some aerial images back to 2009, where you can clearly see that there are greenhouses where there was evidence of cannabis cultivation going on in the site predating 2012.
If I could just add also through the chair, our understanding of the argument from the applicant's attorney is not really that there's a prescriptive easement that they would qualify for, but that the existing easement they believe allows them to use for the cannabis. And we did recommend that it be continued last year so that they could try to work this out with the adjacent property owner. They did, over staff's objection, ask to come to the Planning Commission because they believe that that existing easement allows them to use this for that purpose. Clearly, the neighboring property owner disagrees.
Any other questions for staff before we open this up for public? Seeing none, we will go to and open it up for public comment. And the first public commenter is Kent Sawatsky. Go ahead, Kent.
Kent Sawatsky. I'm not an attorney. Neither is Keenan and neither is John Ford. So I don't know. If you don't have legal representation in this room willing to make a determination for you regarding the standing of this easement, I highly caution you not to engage in what could be a very costly lawsuit with the county. So that's my fatherly advice on this topic. Openly, notoriously, and hostily for a time of 5 years for specific use. But I'm sure Mr. Gans will tell you that until that's brought before the court to substantiate an easement, it doesn't exist. Now, this is just my non-legal opinion. You definitely need to get a legal opinion on this. It kind of sounds like you're being bullied forward to try and do something here, which I don't think will be in the county's best interest. John Ford, on another topic, said in the last supervisors meeting, unless we really have all our ducks in a row, I'm paraphrasing here, we really don't want to move forward with something. This definitely falls in that category. So highly caution you on that. I think, isn't this the one that's called contingent hydrologically contained well? Never heard of that. So that's an interesting topic on this one. I just would hate to see you be one of those ham sandwiches that end up with this decision ending up in litigation and unfounded, even though it may be, still could cost the county a lot of money. So before you move forward, I would get a determination from your attorneys, and they probably will want to have time to research this specific topic and understand more about it. That's just my guess. So that's kind of my fatherly advice on that one. And if you don't have an easement to that property, if it's landlocked except for a specific purpose, which appears to be adjudicated in court for residential, this is a commercial use, and it's not secondary to the residential use. This would be considered, in my opinion, to be the primary use of the property, and it doesn't even say whether they live on the property. So that's probably all irrelevant. I would definitely go to your counsel on this topic, and I think this thing should be definitely not approved on any basis until you have a full-on legal determination, giving county staff, county council time to come to a conclusion that you're good and clear on this one. Thank you for the opportunity to speak.
Thank you, Kent. Next caller is Russell Gans. Please go ahead.
Hello, thank you. I thank the Commission for an opportunity to address the Commission on behalf of the, assuming this is the applicant's opportunity to address this specific issue. Prior to tonight's hearing, the applicant did ask me to specifically address if the easement issue was raised. And I think there are a number of misconceptions that have already been stated that I do want to clarify before the commission takes action on this item. And I do fully endorse and concur with staff's recommendation that the commission go ahead and approve the project tonight, subject to the exception on potential future access issues being adjudicated at a later point in time. The first and fundamental thing for the commission to bear in mind is this is a parcel with a legally recorded access right. And contrary to some statements or interpretation, there are no specific prohibitions or preclusions on ingress and egress utilization in the existing recorded easement. Virtually every easement drafted in this day and age in rural property locations of this nature, if cannabis cultivation is sought to be precluded by the party granting the easement, there's a clear cannabis cultivation preclusion within it. There is no such preclusion in the 2012 easement here. Moreover, if you read the settlement agreement in totality, you will see that not only was the easement granted, concurrently a commercial log hauling agreement was granted as well. There is no preclusion on other commercial activities in the commercial log hauling agreement that was concurrently granted to the prior property owner. Our client, Hog Hill LLC, and its principals, when they acquired the property, all they had record notice of was the easement and log hauling agreement. Again, there are zero cannabis preclusions in those documents. So it is not a circumstance where the client does not have legal access or is doing something contrary to recorded access. It is an unaddressed issue in the previous easement. And again, there is no covenant that binds our client's parcel for the benefit of the now complaining party's parcel on cannabis cultivation. And if you think about it and take it to its logical conclusion, commercial log hauling activities are far more detrimental to roads and require maintenance and responsive conduct than commercial cannabis related activities. So another important point to note is cannabis activities, as the planning director correctly noted, have taken place in the subject parcel. There's aerial evidence of it dating back to 2009. 2014 onward, there's very active cannabis cultivation activities that have been consistent and ongoing. And to Commissioner Pellegrini's comments, yes, indeed, in 2016, our client did seek and obtain the interim cultivation permit and has been conditionally cultivating cannabis consistently from that point in time forward and again prior. So I'm absolutely confident if we go to court, there's any argument that this use being made of the existing easement is somehow not consistent with historic use. There's aerial evidence dating back to 2009 and very conclusive evidence from 2014 onward, even in a legally permitted context by the county, allowing continued cultivation at the site. There are also some other important points that I think the commission should consider that might put you a bit at ease when you consider granting this permit tonight. One of which is there is aerial evidence that cannabis cultivation was ongoing on the complaining party's adjacent parcel. If you look, you will find it. There's aerial evidence on the Brown parcel through which the majority of this segment of Dockweiler Road travels. In addition to that, there is nothing of significance that will change. Commissioner Pellegrini's comment or concern about shifting the burden of proof, well, there really is no proof burden other than what is in your ordinance and demonstration that our client has a legal access right. Staff's assessment of that issue is exactly correct. We do have an access right. And as to the scope and extent of that, if there's going to be a dispute, this isn't the correct forum for that to be adjudicated. Obviously, your job is to serve as a judge and jury as to the scope and permissible use of an easement. That would be an issue resigned for civil litigation, absent some clear direction in the easement that prohibits cannabis cultivation. So in summation, we have an easement, we have a very substantial time period of uninterrupted use, well in excess of the 5-year period for expansion by prescription. We also have a clear situation where we are not overburdening the roadway, consistent or beyond what has been historically the use made of that roadway. And if you look again aerially, they're very substantial cannabis operations that have been ongoing for a decade or more, based on Google Earth aerial imagery, to the north of this parcel. So Dockweiler Road is used for that purpose. What we're asking you to do is grant a permit that's entirely consistent with the zoning of the subject parcel and the anticipated use of the parcel. And what you're being asked to do by those that are opposing this permit is basically read into an easement and create a prohibition that does not exist in the plain text of that written easement. So available for any questions that commissioners may pose. But again, thank you.
Any questions for the applicant by the commission? Seeing none, I will go to the next public commenter, and that is Allison Jackson, please. You there, Allison? One last time, Allison. Okay. She's unmuted, so maybe we'll come back, see if she gets rehooked up. There's another public commenter, Sherry Moran. Hope I pronounced that right. Go ahead. You have to unmute yourself.
Thank you, Alan. That was pronounced well enough. So I'm here on behalf of my family, all of which who are on this call, Gloria Brown, Carolyn Courier, and Cheryl Humphrey, all adjacent landowners, and the land, the Dockweiler Road is on our land. Our family has been on this land since 1918, running cattle. And Kent, I think, said it the best earlier, that somebody is being bullied into this. And I feel like I could even hear that through Russell Gann's statements, that if they could just get this passed by the commission, they could steamroll us into another legal battle, one of which my family members, who are 2 of them in their 70s, are absolutely exhausted from the initial lawsuit process. I want to make a few comments. That in the Planning Commission on September 5th, 2019, we found out about that 2 to 3 days prior and had to madly scramble. And the landowners put forth, to the best of their ability, their foot down and their objections. And we have been through this. We have done this. That Dockweiler Road, nobody's house that is not the road access we take to the housing. So we have no idea what is going on up that road most of the time, unless somebody tells us. I mean, the ranch is fairly large. So we wouldn't know what Josh was doing until September 5th, 2019, at which time I think Keenan said the applicant requested continuance, but I think the continuance came because following the revelation of the precise language in the easement. So I just think when I look at what's written in the report, there is so many untruths and twisted language, and I can understand that this is done out of desperation. It's not that I don't understand Josh Sweet's position of desperation. He has illegally built up his empire there without communicating with any of us until September 5th or thereabouts. Whenever he got wind that, you know what? It's not going to be as easy as you thought because the easement is for residential use only. We have fought that battle. I have had several, not even just several, many. I met with him, had an amicable conversation, said, because this is how I approach the world. But subsequent, because we had to understand what is it you're doing? What is it you're wanting? What is going on up there? As soon as there were any challenges to him, he spoke in such an aggressive manner that I just asked him, please, you must be civil when we have these conversations. And any attempt for me to just say, to contact him after that, he denied, and he didn't answer anything. And he sent, I'm sure this particular lawyer to go to mediation with us. We did talk to the mediators. We said, what do we say? We have nothing to mediate. So it wasn't that we ignored any of that. I mean, all he used to say to me is, if you were a good neighbor, you would give me land access. And these landowners have fought hard for giving him land access. He has access, but not for commercial use. There was a very small, limited qualifier that said you could pull logs during a specific time frame, and he did that. But that was a very small period of time he had to do that. So that was done, and that's good for fire purposes or anything else. And what surprises me is that he told the Planning Commission that he believes the issue is already resolved and that legal access exists. And that obviously didn't come from us. That came from this lawyer, Mr. Gans, who has convinced him that because cannabis was growing up there, that he has the right. But when I read the report, the Planning Commission wrote that cannabis activities were initiated on the parcel in 2013. The claim that there was cultivation in 2012 when the easement deed was recorded has not been substantiated as such. There is no evidence the county has to support the claim that cannabis cultivation was an existing use that could have enjoyed implicit permission at the time that this easement deed was recorded. So you asked him in the presence of evidence to come back. And did he submit anything to show that he had legal access for commercial use, other than just his word from his lawyer, who it just feels is crafting a way to get this passed so they could take us into a civil lawsuit and use the fact that planning has already given him the permit. This just, when does our local government stand behind us by looking at what is legal, what is in the files, what has been fought and paid for? Why do we have to continue to defend ourselves? I live in the Bay Area. I cannot see what's going on. And I have to have family members tell me there's a hearing coming up. My mother's 76. She's fought this. She doesn't have what it takes to fight this. So now I have to fight this. So please, please, I am just asking you just not to turn a blind eye to the bullying that is going on by Josh Sweet on this family. Thank you.
Hello? Hello?
Allison, we can hear you.
Okay, thank you, because I had to call in
yeah.
on my iPhone.
Yep.
Allison Jackson, I just came in on this matter on Monday. I represent Gloria Brown Trust, Cheryl Humphreys Trust and the Florence Anderson Trust. In 2010, the applicant's predecessor in interest, Mrs. Abruzzi, wanted to sell the property, but she had no easements to do it in or out and no way to haul her logs. There was a lawsuit, and my clients gave her an easement expressly limited to a single family residence because she wanted to sell the property and they did not want to worry about any type of commercial venture coming out of it. But they did give her a commercial license to haul the sold, and in 2015 it was sold again to the applicant, and the applicant clearly admits to knowing that there was a need for a single family residence only. Now in 2019 was the first time notice was ever given to anyone of my clients that there was any type of commercial type of activity that would be occurring on this road. And they immediately went to stop it the first time they had notice of it. Staff kicked it back for 1 year for the applicant to prove he had legal access for a commercial venture, and he hasn't. He had a year to go to court and prove it. He hasn't. He has done nothing as opposed to just simply getting an opinion letter. He should have gone to court. Now we're told that the new policy is to simply issue the permit and force a landowner to litigate something that is express, clear, limited easement. That's the now. That's also an untenable policy. The permitting process here, that's not how it's supposed to work. Now, I'll just tell you the realities of life, or that these are tens of thousands of dollars that you're forcing on these people when they have an express easement with the court backup of 5 years. Again, this is not how this is supposed to work. Now, today I find out that there was an interim permit issued for this man to operate this grow without any knowledge given to any of my clients. Now, at this point, he's had a year to establish it, and the only thing he can do is an argument. They have an express easement. You need, at first I was going to say put this over and let him to establish it, but he's had a year. I'm asking you to deny it at this point, have him reapply when he resolve the issue either. Pardon me? Hello?
You're going to have to wrap it up, Allison, please.
Oh, I was wrapping it up, but I cut out and I could not do that. It's time for this to be denied since the applicant has not established a legal instrument showing he has legal access, nor did he take the time to go to court to do it. You've got an express easement, and it is absolutely fundamentally unfair to look the other way and put this on neighboring landowners. This is not how this is supposed to work. Not at all.
Thank you.
Thank you.
Thank you. Next caller is Public 6670. Go ahead, 6670.
Hey there, this is Madeline DeLapp, Humboldt County Growers Alliance. Just listening to this very interesting discussion and want to bring it back that the purpose of the ordinance, of both ordinances 1.0 and 2.0, are about bringing projects into compliance with appropriate land use laws. That is what this project has been doing. There is evidence of cultivation on the site for more than a decade. The project has clearly been accessed through this road for more than a decade. That is commercial use. I think that the attorney, Mr. Gans, summed it up very well. And for the ordinance, it is not about I want to keep it at that and just say, we're trying to bring these projects into compliance. If this needs to be litigated outside of the courtroom, this is outside of the Planning Commission. Planning Commission is about land use. And if this needs to be dealt with in the civil courts, do that. But giving this authorization to be able to move forward and bring this project into compliance is the best thing to do. Thank you.
Thank you. Is there any more public comment on this topic? Seeing none, I will close the public comment. Wait, there's one more. Stephen Liu, go ahead.
Hello, this is Stephen Liu. I work with the particular applicant. I've done some mapping for him. I also represent other clients in the cannabis industry coming into compliance. And as Natalie brought up, it's unfortunate that these access and easement issues come up. But again, the purpose of the ordinance and what we're trying to do here is to give an opportunity for growers to come into compliance, to enter the legal realm. And I think that's what the focus has been for Mr. Sweet, is to be able to have a permitted operation and legal operation on this parcel and on this land. And he's done what he can as far as entering this process in good faith to achieve this. There's also the element too, as was brought up previously with Mr. Gans, is that we understand the neighboring landowners' concern with respect to this, the use of the property. I'm not sure if it's specifically just the activity that is going on there, if it is some other aspect that is bringing this challenge up. Commercial activity with respect to timber was apparently okay. And then there's also evidence of, if it's specifically a concern against cannabis and cannabis activities, there is evidence on aerial imagery of cultivation that occurred after 2016 on those parcels, and evidence of expansion of those activities between 2017 and 2018. And so we're hoping that the landowner can secure and enter, come into compliance and follow through with this, and focus on that particular element. Thank you.
Sorry about that, I was muted. Seeing no other callers, I will close the public comment and bring this back to the commission for discussion. Get to my panelists. So Ronnie, you got your hand up.
I think that, can you hear me? Yeah.
Yes.
That since the applicants had a year and a few months to establish this, he's since the last commission meeting, he could have taken the civil action that he needed to take and not bring it to us without really moving forward, like other than to get Russ Gann's opinion on the matter. And at this whole time, he's establishing a prescriptive right on this. And I think the settlement agreement clearly shows to me that it says for residential use only. And for those reasons, I'd move to deny the permit and to pull his interim permit until such time that these issues are resolved by the applicant, and then he can reapply.
Is that it? Thank you. Mike Newman, you have your hand up.
I'd like to ask the director again, just to make sure. I believe you had said that there was no specific language in the ordinance, the 1.0 ordinance, about access to property.
That is correct. In fact, the zoning ordinance does not have specific language requiring proof of access.
All right, thank you.
I just want a point of clarification. Ronnie, were you making a motion in your statement that you wanted to deny
the permit and pull the interim permit until such time the applicant can get the civil matter taken care of with the regard to the access?
Okay, since that, I thank you, Director, because I thought she was just saying she wasn't going to be for it. She was actually making a motion. So I would ask if there is a second for that motion, and then we can have some more discussion. Anybody care to second that motion? Seeing none, I would say that that motion fails for the lack of a second. Sorry, we'll get back to that though. So we got a lot of hands up now. So Noah, you're next.
Thank you. Yeah, I just, we didn't think we were quite ready for a motion. Several of us had our hands up. I guess I just, I sympathize with the applicant. I sympathize with the neighbor. But I really do think that the applicant has done a pretty good job of showing that they have legal access. I mean, I will say for my part, and I have no stake in this project and no familiarity with other than what we've heard tonight, but I have seen a lot of easements, and they often don't specify a range of uses that are considered to be ancillary to access to a residence, and there was some language in that one, as I recall, that said, and appurtenant uses or something like that. I can see that there's a legal argument here, but I'm not convinced that it's at all black and white. And I'm not really sure that it's who's being bullied by whom, to be totally honest here. As far as I'm concerned, this does meet all the requirements of the ordinance. I thought it was interesting, but not really pertinent to our decision that, the attorney, Mr. Gans, I believe, said that the aerial imagery shows that the subject parcel, the disputant parcel itself, has evidence of cannabis. And I think I saw Mr. Director Ford nodding his head at that. And, so if that's the case, even more so, I'm not sure what this is really about. In any case, that's just my 2 cents. Thanks so much.
Sorry, I was muted. Melanie, I see you have your hand up.
Thank you, Chair. So I have a couple of questions, actually, about the easement. I both am I guess, burdened is the legal term, and benefitor of 2 separate easements myself. And my understanding, and I'm in no way an expert on this, is that the easement would have been transferred, whether it was informal or formal, with the property. And I've heard one argument that, well, the property was residential. And I couldn't find anything really that would substantiate that argument, that it's no longer valid because, it used to have a different use. So, for example, if my property were to change from, what it is now to something else, the easements that I have would nonetheless stay. So it seems to me that from at least what, within our jurisdiction or within our deliberations, we don't really have anything here that would push us to deny the permit. We're not a panel of lawyers, and if the planning staff has told us that they have done their due diligence and they believe that, you know, this is something that could and maybe, you know, should be going by the regulations approved, then I would have to say I agree with that. And I did do some research into easements. And again, it's my understanding that the easement wouldn't have been coded somehow to be forever residential. So I guess, you know, my question to staff is just that. Did you also find that? I know you spoke of it earlier, but that was my understanding. Thanks.
You want to answer that, Director?
Sure. So one of the ironies of this is that while the easement does identify residential and appurtenant uses, one of the ironies in that is that the properties own TPZ and AE, which in 2012 didn't allow residential as a primary use. It allowed agriculture and basically timber production.
Yeah, that's actually where I was going with this, because, for example, if you're, you know, then if you then had something change, wouldn't any easement just transfer with it? I know it would in most cases.
Yeah, one of
I'm not gonna.
You're muted.
Thank you. I'm not going to, and I shouldn't comment on the legality of an easement. I think our conservative approach is to stay within the box of what the county policies and ordinances require. And in this particular case, there is not a requirement that they demonstrate proof of access. They have provided that they have an easement. They have given us a reasonable argument that they have the use of that easement. That easement reasonably can apply to the cannabis cultivation. And so based upon that, we're recommending approval.
Thank you. Yes, that's exactly what I found also. And I couldn't find anything convincing, you know, otherwise. So, all right. Well, thank you.
Director Mitchell. Commissioner Mitchell, I should say.
Thank you, Mr. Chairman. One of the early on meetings that I had when I was first put on the commission had to do with a similar situation where there were two neighbors, you know, in a dispute over access. And I felt really strongly that I could tell that one of the two of the lawyers was lying, and it really, I really wanted to adjudicate the matter and, you know, do what I thought was sort of right in between the neighbors and the parties. But our former chair, Bob Morris, you know, taught me a lesson that's really stuck with me, and that, you know, we are not experts on legal matters, and especially legal areas that are so nuanced and complex as easements. You know, it's not as simple as reading one easement document and being able to capture the entirety of the law and what that means going forward and such. And so in this case, I really would like us to stick to the land use decision, and any dispute between neighbors, be it civil, criminal, or otherwise, be left to the appropriate body which would adjudicate those matters. And as it relates to land use, I was really struck by the fact that this project is ameliorating and correcting issues where there was cultivation going on in a streamside management area. And so if we were to deny this project, we would be stopping restoration that could affect water quality and these streamside management areas. And so based on that, and just based on the fact that Attorney Gans has provided us enough information, which is consistent with staff's recommendation, I'd be prepared to make a motion to accept and move forward with this. And I'd be happy to entertain some sort of additional requirement that said that if a court of competent jurisdiction found that access did not exist to the parcel, then that could trigger either a review or a flat out revocation of whatever our action is here today. Thank you.
So we have a motion with a condition put on it. Do we have a second for that motion? And we still have hands up for discussion. I have some thoughts as well. So is there a second for that motion?
I'll second it.
We have a motion and a second. And do we have some further discussion on that? I saw your hand back up, Ronnie, and I'd like to chime in behind you.
Well, just to kind of address something that Brian had said when, to get it adjudicated in the proper place, I guess. Well, my question is, why in 2019 then in September did the commission kick it back at that time? And haven't moved forward at all. We still have the same issue kind of dangling out there.
Okay, well, you took one of my points I was going to bring up, so I'll scratch that one off. The second thing I was going to bring up is there is an easement across this, and the people were very specific. They were so specific in that easement that they said, we're going to allow you to go to a residence and you can have logging trucks go across it. That's a commercial use. But they didn't list other commercial uses that could happen. Now, maybe at the time they couldn't foresee that it was going to be a cannabis farm there or anything else, but they said, we'll allow this use. So in my mind, they were saying what could happen other than just driving back and forth to your residence. So I think that was very specific, and I disagree that they could just do whatever they want there. I think the people put foresight into and thought into how they wanted that to read, and that's what they did. I'm not against there being a cannabis grow back there, but if it has to cross people's land and they have to get permission to go across it, then they have to live with the conditions that those people set. So I think that's one point. The other point is I am maybe going to butt heads with the director here, but for projects, and I would say, especially for commercial projects, I would think that you would have to show proof of access. You would have to show proof of an easement. And I don't think that this applicant has shown proof of an easement for this type of project. I'm not saying that he hasn't shown proof of easement to go to this property, to go to the residence that's there and access his property. If he wants to log it, well, he can drive trucks across it. I don't think he has shown proof that he can run a commercial cannabis business there. And I don't see how the county can say that we just don't have to show proof of an easement. I mean, if you were doing, and I often say this, and I probably sound like a broken record, but doing a real world project, you're doing a subdivision, you were doing some other kind of a project, I can promise you the county would require that you had all the proper easements and they had been vetted by legal counsel and everything before you would get approval on that project, before it would get to the supervisors to be signed off. So,
hey, Alan?
Yes.
Would it be possible to ask county counsel to weigh in? I mean, you keep talking about the written.
My last point.
The written access agreement clearly has, bumpers around it or guideposts surrounding it. But you haven't really addressed the issue of the prescriptive easement. You know, my understanding is at a certain point, if you've been using a parcel of land for specific hiking, that at some point becomes a prescriptive easement, whether or not it's right.
I agree, Brian. I'd like to finish my points. I let you butt in, but I'd like to finish my point, and that was one of them I was going to get to. I don't agree with the issue that a prescriptive easement just exists and it can't be taken away. I would point you to when the river bars were closed to the public in the Ferndale area. Those river bars had been used for hundreds of years by the people of Humboldt County. And then that was taken away. Okay, so what's to say if we're calling this a prescriptive easement that they couldn't take that away from this person and say, well, you know, we decide now you can't have that prescriptive easement. They get taken away. There's a lot of other examples that could be brought up. That's just one that's not too long ago, and there's a lot of people that are very upset about it. So anyhow, I'll stop ranting, and Mike Newman has his hand up. Go ahead, Mike.
Thank you. Well, I have to disagree with several points there and bring us back to the motion. You know, because there is no specific language, you know, in the 1.0 ordinance, and the zoning for that parcel was AE and TPZ, basically without residential use there, that probably that easement was ill-advised in the way that it was done. And I see this going forward because the 1.0 ordinance was to bring things into legal standing. And because of approval of this permit does not specifically authorize then the use of the existing easement, that access, I think the landowners still have some standing in civil court that they need to work on. We've dealt with this on a couple of other occasions in the past year or two while I've been on the commission. And that's been our standing on it, is easements and stuff is more of a civil matter, and that's not something for land use that we can decide. Everything else seems to come into play for this permit. And I would be, with the conditions that are on here, be in saying, yes, we need to go ahead and approve it. There is one thing I wanted to point out. It's just a spelling part, but on page 15 in the ongoing requirements, number 14, you just need to change the word sue to use in that. So thank you.
Seeing no other hands up, I'd like to ask if council would like to comment on this.
Thank you, Chair Bongio. So I have reviewed Mr. Gann's letters and Ms. Jackson's letter. I did have time to look at the authority in Mr. Gann's letter. It really, I mean, he makes a good presentation and backs up his points with authority that fits the points. And I'm sure that Ms. Jackson, given time, would do the same. It really is a factual dispute, and I agree that this isn't the space to resolve that factual dispute to the extent that there is one. I also agree that there is no requirement for access in the cannabis code. They have demonstrated access. The question is to what extent that access goes, and that really is something that should be resolved in civil court. The question is whether they've done enough to comply with the cannabis code and meet with the provisions of that. And we did look at the case files to see if there would be anything that could help us. But neither of the cases went to hearing, so there's no actual ruling by a judge and no trial or anything. So that we don't really have anything from the cases except the language of the settlement agreement to help. And again, we don't want to be in a position of fact-finding about that civil dispute.
Great, thank you. Well, I'll bring it back to the commission. We have a motion and a second, and it's been a while, so I would ask the maker of the motion to restate it. Yes.
I'd be happy to. And may I just start by apologizing for cutting you off, Alan. I thought when you took a breath that you were finished with your sentence, and I did not mean to take over.
I was just getting
your
going.
train of thought. That being said, my motion was that we find that the commission has considered the addendum to the mitigated negative declaration adopted for the commercial medical marijuana land use ordinance pursuant to section 15161 of the state CEQA guidelines, make all the required findings for approval of the conditional use permit and special permit based on the evidence in the staff report, and adopt the resolution approving the proposed 30 Deep LLC conditional use permit and special permit subject to the recommended conditions, with the additional condition that should a court of competent jurisdiction find that the applicant does not have the legal right to access the parcel, then this matter be brought back to the director for appropriate adjudication or dispensation, I guess I should say.
Does the second concur?
Yeah, as the seconder, I just would want to make clear in the very end, in the crucial additional part of Commissioner Mitchell's language, that I think the key issue is, should a court of competent jurisdiction find that the easement prohibits the use or something like that? I mean, because they do have legal access, so you just need to be clear about what it is that we're asking, what test we're asking either the applicant or an opponent to meet.
The director would like to chime in.
So if it'd be acceptable to the motion maker to say that finds that there's no access for cannabis cultivation.
Fair enough. I mean, that sounds good to me.
That sounds good to me.
So we have a motion and a second.
I have a question. I have a question on that.
Go ahead, Mike.
Since the 1.0 ordinance doesn't state anything in there, isn't that going against that still?
No, it's recognizing the fact that this action is not superseding what a court may do. And that if the court decides that there's not the right to use that easement, that this approval is not attempting to supersede a court action, and that some other form of access needs to be found before the permit can be utilized.
And that, trying to unmute myself, so that still is okay then with the ordinance for the 1.0.
Mm-hmm.
Okay.
Any other discussion? Seeing none, I will ask the clerk to do a roll call vote.
Commissioner Alan Bongio,
No.
Ronnie Pellegrini,
No.
Noah Levy,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Yes.
Melanie McGaver.
Yes.
Thank you.
Motion carries. With that, we will take a 5-minute break and get back to this. We still have so many to do. I don't doubt we're going to get through them tonight. So 5-minute break and we will be back. Thank you. Yeah. That was, All right, welcome back, everyone. During the break, the director made a suggestion that we do a little housekeeping right now because we're getting through this so slow, and do the ones that are being continued to a future date to get those out of the way so we won't come up against a time crunch at the very end. So the first one of those items was, number C6, Emerald Coast Genetics Incorporated, conditional use permit, special permit in the Pickle Hill Road area. And is it continued to a certain date or?
Continue to January 7th.
So I'm going to open this up for public comment. And I'm going to make it quick. We're just trying to do some housekeeping here.
I'm trying to be quick. I tried to unmute and didn't happen. Okay. So anyway, I will make it quick. I do have major concerns regarding this project. It'll be brought forward later. Power supplied by PG&E with a backup generator. Again, I would ask that that be metered as in prior processes here. I would ask that the PG&E again be the environmentally conscious process, and hopefully that the Emerald Coast people will go ahead and volunteer to do that if they're listening at this time, if they took the time to participate in this process. We have an existing outdoor cultivation, and I always have a concern regarding outdoor cultivations, which may be outdoor cultivations, and yet now we're going for double cropping. So those are my concerns, and I do support you continuing this. And at that time, I think hopefully you will address some of those issues. Thank you for my opportunity.
Thank you, Kent. Any other public on this topic? Seeing none, I'm going to close the public comment and bring it back to the commission.
I would like to make a motion to continue this item to January 7th.
I'll second.
We have a motion second. Any discussion? Seeing none. Laura, roll call vote, please.
Commissioner Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman,
Yes.
Ryan Mitchell,
Yes.
Melanie McCaver.
Yes.
Motion carries unanimous. So the next one is
Organic medicinals, number 7, the next one right after it.
Yes. Organic Medicinals Incorporated, special permit and zoning clearance certificates, 125 Shively Flat Road, Shively area. Once again, I will open it for public comment. We have one. It's Kent. Go ahead, Kent.
Again, quite rapidly, this is an RRR, which is very unique. I hope this moves forward. And I did wish to commend these people. Appears to be a new outdoor, and it's 100% renewable energy from Repower. I appreciate that, and the solar power. And also seasonal laborers are hired from an employment agency and carpool to the site. So there are some really good things about this particular project. But since you seem to always have these addendums and things come in, which we have no access to and don't know what they are, I will make further comment, hopefully, at such time. The other comment I wanted to make, it sounds like they only need 12,000 square foot gallons more of water storage on this one, and then they will not have to be doing anything regarding any kind of other water sources. And so I support this project generally with that small change. Thank you for my opportunity to speak.
Thank you, Kent. Any other public comments on this? Seeing none. Oh, wait, there is one. Go ahead, Neil.
Yes, I just wanted to confirm that this application was being continued to January 2021. Is that correct?
Yes, it's January 21st.
Thank you.
2021.
I have no further comments, and I'll comment at that time. Thank you.
Thank you. Any other public? Seeing none, I'm going to close public comment, bring it back to the commission. Go ahead, Ron.
I'll move to continue to the January 21st meeting.
I'll second.
Motion. We have a second in Noah. So Laura, roll call vote, please.
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Leve,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Yes.
Melanie McCaver.
Yes.
Thank you.
Thank you, Laura. The motion carries unanimous. So with that takes care of our housekeeping, and we're back to item number 3. Reed Mountain Farms Cooperative Incorporated Conditional Use Permit and Special Permit, 1000 Reed Loop Road in the Benbow area. Could we have a staff report, please?
Not the director, but Chairman, I'd like to recuse myself on this item because of some of the participants in this permit.
Thank you.
So could I have member of staff give me a call on my cell phone? I'll sign off right now. Thank you.
Thank you, Mike. That's how you do it. All right. We'll take that staff report now.
All right, great. Good evening, commissioners. My name is Megan Ryan. I am the sign planner for the Reed Mountain Farms Cooperative Incorporated Conditional Use Permit and Special Permit Project. The project was first scheduled for the January 23rd, 2020 Planning Commission meeting and was continued to allow staff to address comments received from the Department of Fish and Wildlife, which I will discuss in this presentation. The proposed project is a conditional use permit for 40,370 square feet of cultivation, consisting of 15,000 square feet of mixed light and 25,370 square feet of outdoor. Immature plants will be sourced from a licensed nursery until the propagation areas are developed. There will be 2 harvests of outdoor and a maximum of 4 harvests of mixed light cultivation annually. The applicant is proposing to construct a 4,000 square foot structure to be used for 400 square feet of propagation, drying, curing, and storage, while further processing will occur off-site at a licensed processing or manufacturing facility. There'll be 5 permanent employees and up to 15 seasonal employees during harvest and replanting. Power will be provided by a solar array with battery storage, and generators will be used as a backup power source only once phased out within 2 years or no later than 2023. If the applicant cannot demonstrate solar power or connection to grid power by 2023, this permit only authorizes outdoor cultivation until the power source can be modified. Conditions of approval require the applicant to submit a power plan within 90 days of the effective date. The subject parcel is accessed from Reed Mountain Road, approximately 3.62 miles from its intersection with Benbow Drive. Near the community of Benbow. A road evaluation report was prepared by North Point Consulting and is included in attachment 4 of the staff report. The report concluded the road is the functional equivalent of a category 4 road and does not require improvements. This road can accommodate the traffic associated with the proposed project. This slide is showing an aerial image of the 2 main cultivation areas on this subject parcel. Water for irrigation is supplied by a groundwater well and rain catchment. Annual water use is 475,000 gallons, or approximately 3.8 gallons per square foot. There are currently 2 25,000 gallon rain catchment storage tanks on the subject parcel. The applicant is proposing to add an additional 40,000 gallons of storage for a total of 90,000 gallons of water storage. There's 1 streamside management area located in the central portion of the parcel that is tributary to the South Fork of the Eel River. Marbled murrelet habitat is located 1.34 miles to the southwest. Conditions of approval require noise to be limited to 50 decibels at 100 feet from the noise source or edge of habitat, whichever is closer. The applicant is also required to adhere to dark sky standards for the use of artificial lighting for mixed light cultivation. Conditions of approval require the applicant to demonstrate compliance with these conditions prior to use of lights, fans, or dehumidifiers. The California Department of Fish and Game requested additional information regarding northern spotted owls and their comments, which the comments are included in attachment 5 of the staff report. The nearest northern spotted owl activity center is located 1.76 miles southwest of the subject parcel, and the nearest observation is located 0.40 miles northwest of the northern cultivation area. Surveys for NSO have occurred associated with a non-industrial timber harvest timber management plan from 2017 to 2020. The results of those surveys are included in attachment 4 of the staff report. The table on the slide shows the number of surveys that occurred each year and a very brief description of the results. In summary, 1 pair was heard in 2017. NSO was detected in 2 surveys in 2018. No NSO were detected in 2019. 1 unknown owl species was detected in 2020, and no NSO were detected in follow-up surveys. This slide is showing the overall an overview of the subject parcel from the site plan and the staff report. The proposed project includes remediation of historic cultivation areas and consolidation into one central location, which is located in the northeast portion of the parcel. The restoration of cultivation site 1, as shown on this map, requires a special permit for work within the streamside management area. A restoration narrative was prepared by North Point Consulting Group and is included in attachment 4 of the staff report. The western cultivation was a historic, the western cultivation area, cultivation site 1 on this map, was a historic log landing that was expanded in 2012 for cannabis cultivation. A class 2 watercourse was diverted to circumvent the graded flat. The applicant is proposing to restore the entire cultivation area and the stream channel to realign with its pre-disturbance condition and recreate the associated riparian corridor. The total area to be restocked with timber on the parcel is 3.03 acres, as it includes 2 additional smaller cultivation areas. In addition to restoring the historic cultivation areas, the applicant will no longer need the access road that goes to cultivation site number 1. Therefore, at least approximately 1,035 feet of access road will be retired and restored or restocked, excuse me. The applicant is proposing to relocate the cannabis cultivation area in the western portion of the parcel to the northeastern portion of the parcel, as I stated. This slide is showing the final proposal of the layout of what the relocation area would look like. The relocation of cannabis cultivation to this location would result in the expansion of the eastern cultivation area to 2.87 acres to accommodate the relocation of cultivation from the western cultivation area. Staff supports remediation and on-site relocation, as the final configuration would result in an improvement to the baseline environmental conditions. The project, as I stated previously, the project was continued from the January 23rd, 2020 Planning Commission to address the concerns of the Department of Fish and Wildlife. Comments from the Department of Fish and Wildlife are included in attachment 5 of the staff report. Comments from CDFW raised concerns with the cultivation area verification, timber conversion occurring after January 1st, 2016, wanting to see an increase of the timber stocking requirements, additional information on northern spotted owls, use of artificial lighting, generator use, and concerns regarding cumulative effects associated with the non-industrial timber management plan. To address the concerns of CDFW, the applicant has made the following project revisions. A 6,000 square foot reduction in the mixed light cultivation area to reduce the need for artificial lighting. A reduction in proposed structures from 2 4,000 square foot structures to 1. Trimming will be conducted off-site at a licensed facility. Previously, it was proposed to be conducted on-site. And within 2 years, the applicant will cease the use of the generators and the primary power source will be solar. The applicant may also look into grid power, but depending on feasibility, it may rely on solar power exclusively. As described in the executive summary, staff determined the cultivation area verification was based off of 2014 and 2015 imagery. Therefore, the applicant was informed that only 1 year can be used to determine the baseline condition, and that year was 2014. Timber restocking requirements are in the less than 3 acre conversion mitigation plan as recommended by a registered professional forester, and that's included in attachment 4 of the staff report. As stated previously, conditions require noise and light attenuation measures, as well as adherence to the restoration plan proposed by North Point Consulting. The development of the NTMP follows strict guidelines for timber harvesting, which includes environmental analysis, and to develop a plan that has less than significant impacts. The project as proposed is a net improvement from the baseline conditions, and staff prepared an addendum for this project. The revised project materials were provided to CDFW in November 2020, and no additional information or communication has occurred with their agency. The Planning Department recommends the Planning Commission find the Commission has considered the addendum to the mitigated negative declaration, made the required findings for the conditional use permit and the staff the conditional use permit and the special permit based on the evidence in the staff report, and approved the Reed Mountain Farms Cooperative Incorporated project subject to the recommended conditions. This concludes my presentation this evening. I'm available to answer any questions. The applicant and their agent are also in attendance. Thank you.
Thank you. Any questions for staff?
I have a real quick one.
Go ahead, Noah.
Thank you, Megan. That was a good presentation, but one thing that I recall thinking was slightly ambiguous in the staff report and in your report is, I appreciate that the applicant has agreed to shorten the time frame in which they will rely on generators to 2 years and commit to having it in place by 2023. I guess I just thought we should be explicit about whether we are requiring non-carbon power for operations in 23, or are we requiring that it be in place by the end of 23? Because it seemed a little ambiguous. Thank you.
Thank you. No, any other questions? Seeing none, I will open this to the public, and I'd ask that the applicant, if they want to speak last so that they can address any of the questions that they hear brought up. So the first one would be Kent Swatsky. Go ahead, Kent. Got to unmute. There you go.
2 tries, got it. There's a discrepancy here, in a major discrepancy in this thing. What I see before me is not necessarily the same project. This says power will be provided by solar array and battery stored with a backup generator, and now we're talking about generators for 2 years. So this was not noticed. This was not noticed in the record as far as what's going on here, and that always distresses me. You have a 1 acre cultivation here, and a maximum of 20 employees. That sounds like more than you normally see. You had 2 4,000 square foot 2-story structures. I guess it's down to 1. Even a 4,000 square foot 2-story structure on this is more than I see for this size of project. 475 gallons annually for irrigation with a water storage of 90,000, the location in here, I find it very difficult not to see that this well that's a source of water is not hydrologically connected. Anytime I see a major river within a short distance, that's kind of a given. It just one of those things. It doesn't seem to all. It seems like a project, and what's notified here is different. And I hopefully they will stay with what they said. Power will be primarily provided by a solar array and battery storage with a backup generator. Is that true or not? And if not, it hasn't been noticed on the agenda correctly. And maybe this needs to come back and be noticed correctly so that we can tell exactly what the project is to be. Seems to be an ongoing thing happening with these kind of projects. And that's why they are going to consistently be pulled off of your consent calendar to deal with these kind of issues. So we're at item number 3. Those are my major concerns on this one. Something just does not quite smell right regarding what's been put out forward and what's happening.
Thank you, Kent. Director, would you like to address that?
I think the issue there was being raised relative to many of the different components of the project. And there's things that are specifically reviewed and approved and things that are part of the are kind of supplemental accessory to the project, which do tend to change a little bit without requiring renoticing a kind of redefinition of the project description.
If I could, through the chair,
yes.
One of the things that I believe Mr. Sawatsky mentioned was the confusion between the notice and the requirement to eventually go completely to solar and or PG&E. So the project is currently utilizing generators for backup. And so, and I believe that was in the public notice. We are recommending a condition that the use of the generators need to cease entirely before 2023, I believe, or may have mentioned that was even going to get moved up. So I don't believe that there is an inconsistency there in the notice. So I just wanted to clarify that.
All right. Anything else? Good. Okay. Next caller is Richard Landis.
Hi, I would like to just offer my support for this project. I've been up to the site many times, and I just wanted to testify that it's very environmentally clean. This group shows a commitment to taking care of their land and doing things right. And anyway, I feel like it would be good for the community and also help provide jobs. Thank you.
Thank you. Next caller is Thomas.
Good evening. You can hear me correct?
Yes.
Okay, Thomas Mulder here. Full disclosure, the way it was noticed, it said in the Bimbo area. I happen to own property in the Bimbo area. So as you noticed before, those of you on the Planning Commission that have seen projects in the Bimbo area, I've commented on. I read the staff report, and I actually was interested by quite a bit of things, and I felt there was an overreach from DFW. From my understanding, timber operations have no relevancy on the cannabis operations, and it's excluded from the timber harvest plans, all of those type of things. I know this because I've gone through a THP. The only thing that cannabis and timber are the same is you have to show that you can still run your timber harvest operation without the cannabis affecting it. So I think you need to remember that. The comments by DFW as far as the NSO habitats fragmented, I noticed that there was quite a few meadows that the DFW was using as fragmented that were natural meadows. Generator use. This is a 1.0 application, and I'm not saying I love it or I don't love it, but we have to remember generator use was allowed under Ordinance 1.0, and there has been projects there's a project in Bimbo that you've approved that has a 60 kW running 24/7. So just think about those kind of things when you're putting these other regulations on projects that are outside the ordinance. It's something that you really, really need to consider. As far as the employee count, Kent, I would tell you this is one of the first applications I've seen in a while that actually, or one of the few applications that has the proper employee count for what they're doing and the proper water usage count. As a cultivator, I realize per square footage what type of applicant or what type of employees you'll need. So please, as you're trying to add these things, consider what the ordinance was when the applicant applied. Thank you for the opportunity to speak.
Thank you, Thomas. Next caller is Britton Price.
Good evening. Thank you, Commission, for this opportunity to speak. I too wanted to offer my support for this particular opportunity. Really, the gentleman, the applicant, is really a pillar within the Benville community, specifically the Reed Mountain community. He manages the road up to his property and manages that, making sure that it's graded and really pulls all the neighbors together. And I see this as a strong, positive impact on the local community. Thank you.
Thank you. Next caller, Natalie Delap.
Good evening, Commissioners. Natalie Delap. That's weird. I can see myself on the screen. I am also calling to offer my support for this project. And I just want to come back to, this project came before the Planning Commission and then it was continued back in January. And the amendments to this project are really pretty, they're significant amendments, specifically to completely cease use of generators. And I want to, Kent, you've been pulling projects and bringing an issue with generators, and a lot of these projects are being amended to become even more environmentally sustainable. That being said, I want to make a point going back to the very first project that we heard tonight, that there's these additional conditions that are being put on where it's like, okay, no generators. We want you to get onto PG&E. Okay, great. You're on PG&E. Now we want you to use the Repower renewable blend. And we're continuing to move the goalpost. And applicants are doing everything they can. They signed up under 1.0. They're following 27 conditions of approval. They have another 20 to 30 conditions of approval. And then they come to the Planning Commission and then they get more conditions of approval. And these applicants are doing everything they can to come into conformance, to bring these properties into compliance with all of these environmental laws based on rules that they were originally given. So with that, I think that Reed Mountain Farms and Amos have done an incredible amount of work. So has the Planning Department and all of the agencies that have been out on site to bring this project to the state that it is today. And I ask you to please approve it. Thank you.
Scott Bauer. You there, Scott?
Took me a second to unmute. Hey, Scott Bauer, Department of Fish and Wildlife. I just want to say we appreciate the revisions, and we have no further comments at this time. Thank you.
Scott. Any other public on this? Seeing none, I'm going to close public. Whoop. Praj White, you got in the bell. Go ahead.
All right. Good evening, commissioners and staff. First, I want to share my respect for staff and commissioners and all the volunteer effort. I know how hard you guys all work. I wanted to touch base that the applicant is here with me tonight and has been very proactive, involved in this project and this process. And has been, held the ground of anything that needs to be done to address the project, become compliant. move forward. He's demonstrated all the characteristics of not only a good client, but a good community member. And I appreciate that some of the comments from the community echoed that. I wanted to touch in on the well comment that was mentioned by Ken. The way that we put together notification to the Department of Fish and Wildlife is we include a copy of the well log and the information and the location to CDFW so that they have ability to comment if they choose to. In this case, the notification went in and there were no comments regarding the well and its isolated characteristics. I also wanted to touch base on power. This is something that we've been watching projects come up, and the use of hydrocarbons really out and fossil fuels out in the hills and running generators. This applicant really did build a business plan and a vision going forward for his property, continuing to use generators and understanding that that was part of what it takes to operate on this property. And ultimately, recognizing the trends and the changes in the community, stepped forward and said he was willing to make that change, even though it completely changed his business plan. And that ultimately, solar cost with battery backup generators, solar with battery systems and backup generators are really fairly expensive. When we make a condition that says, even for the most simple, basic elements of power, that would be just some fans, maybe a work light, a little bit of function in the buildings, that is a commitment to nearly a $500,000 system when an applicant chooses to listen to the community, listen to the concerns, and voluntarily adjust their project to be connected or to get off of fossil fuels and off of the generators. In this case, PG&E will be contacted and we will look to them for a solution. It may be in the ballpark of $1 million. And so I just wanted the commission to hear what a big commitment it is on the applicants when they make this transition. And, in this case, the commission or the staff report gives him 2 years of operation before the generator needs to be removed from the operation. I know it's a tough request, but I want to throw it out there that, it is difficult to get PG&E in a hurry. And for PG&E, 2 or 3 years may be a hurry. So if there's any consideration to pushing that date back 1 year and allowing 3 years for the applicant to get to PG&E or a full service or a full solar system, that would be great. With that, I really appreciate your guys' efforts, and I'm here to answer any questions, and so is the applicant, should you have any more. Thank you.
Any questions for Praj while he's there? Go ahead, Noah.
Yeah, I guess I admit they're not currently on the solar system yet, right? I mean, I appreciate the investment that the applicant has made to switch to full solar or PG&E and to only use backup generators, as a backup. I just want to be clear that they're relying on generators for other power for the next 2 to 3 years. Is that correct?
Yes. Yes, that is correct. That is correct.
Okay, yeah, just thought so. Just wanted to make that clear. Thank you.
Thank you. Any others? Seeing none, the next speaker is Stephen Jeff.
Can you hear me?
Yep.
Hello, can you hear me?
Yes.
Okay, I'm familiar with the applicant for 25 years. I live in Piercy, California, and I haven't been to his farm since it got started, but I met him through bicycles, and he organized bicycle rides, and him and his brother were the first ones that had electric bicycles and motorcycles around here. And if anybody wants to get off fossil fuel, it's him, and he's serious about it. So that's all I have to say.
All right. Thank you, Steve.
He'll do it as quick as he can.
Thank you. Any other public commenters? Seeing none, we'll close the public comment and bring it back to the commission. Any thoughts? Questions? Ronnie, go ahead.
Not about this, but did we get Mike back on the call? Did we call?
No,
Not yet.
we're not done. Is that all you had? Okay, Melanie, you have your hand up.
Yes, thank you. I just wanted to say that it seems as if the applicant has done everything that we as the commission had requested last time, not that long ago.
Any other comments? Or is that it? Brian had his hand up, and then Noah.
Thank you, Mr. Chairman. I just wanted to ask, probably best for staff, but when CDFW sends a list of comments and then staff and the applicant work together to do their best to address those comments, does CDFW actually comment back that yes, these modifications do adequately address our concerns, or is it up to staff to make that determination as far as whether or not it has met the spirit of what's been asked by the state?
In preparing for the project, I commonly will send a response back to CDFW that includes a kind of a narrative that addresses what their comments are and the revisions. In this case, I think in attachment number 5 of the staff report, that response was included and the revised project documents were sent to CDFW. When we get that response back from them, it's great. We don't always have that response back. So I appreciate that Mr. Bauer was here this evening at the hearing.
Thank you. Noah, you're next.
Yeah, thank you. Well, I too appreciate, I guess I just wanted to, I had another comment which is momentarily escaping me. I appreciate that Mr. Bauer actually chimed in, though, since we did have some history of concern by DFW about this project at the earlier hearing. And given that there was a sort of absence of a further response in the staff report, it was helpful to have him call in. I actually had another comment, but I've lost it. So if it's important, I'll raise my hand again.
All right. I see Scott Bauer has his hand up. So go ahead, Scott.
No, thank you for letting me comment. Yeah, we try and get back to the county, and we do appreciate receiving the feedback from our initial comments. I'm down a person to COVID tracing, and that's our main person that responds to these CEQA comments. So I apologize, but like everybody else, we're kind of stuck in a difficult situation with COVID, and we do our best to respond when the county and the applicant provides, revisions. So thank you to the applicant and the county, and we'll try our best to respond to those revisions. Thanks.
Thank you, Scott. Any other comments or questions for the commission? Go ahead, Noah.
Oh yeah, I know what it was. It was just this about the 2 years or 3 years, and Praj White suggested that while it says there's a commitment to get off generators entirely within 2 years, he would appreciate if we could extend that to 3 years. I would support that, just knowing from the experience of myself years ago and others that it can often take several, it's really hard to get PG&E to do it in 2 years. So if PG&E is the best option, I think we should extend 3 years to look into carbon-free power solutions or clarify that to the extent it's not clear.
Anyone else?
I think that's a good idea.
Anybody want to make a motion? Lonnie?
I'll take a stab at it. Move in the effort of moving things along. I would like to move that the commission has considered the addendum to the mitigated negative declaration adopted for the commercial medical marijuana land use ordinance pursuant to section 15164 of the state CEQA guidelines, make all of the required findings for approval of the conditional use permit and special permit based on evidence in the staff report, and adopt the resolution approving the proposed Reed Mountain Farms Cooperative, Inc. project subject to the recommended conditions.
Do we have a second?
I'll second.
We have a motion and a second. Do we need clarification to add that 3 years on that, or is that? So Ronnie, would you be agreeable to add that the power, they have 3 years instead of 2 to get the power?
If that's the commission's pleasure, sure, I'll amend the motion.
All right.
I agree.
All right. We have a motion second. Any discussion? Seeing none, I will ask Laura to ask the question.
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman. Oh, I'm sorry, Brian Mitchell
Yes.
and Melanie McGaver.
Yes.
The motion carries with 5 yeas and an extension.
Let me get Mike back in.
And Mike, yeah, somebody's going to call him. All right. Give Mike a second to get back with us. And the next one we will be moving to is item number 4. WC Grace LLC conditional use permit in the Willow Creek area. So we'll take a staff report on that.
Hi, my name is Megan Acevedo. Good evening, commissioners.
Megan, before you start, can you just wait a minute, please? I'm sorry.
Okay.
We're waiting for Commissioner Newman to get going back up with us. Okay. So wait for him is what you're saying. Mike, are you there yet?
Megan, could you stop the screen share, please, so we can see when Mike comes in?
Okay.
Thanks. I know. Yeah.
All right, we're trying to wait for Commissioner Newman to get back on, but he must be having some kind of technical difficulty. We'll start the presentation. So go ahead, Megan. Apologize for stopping you.
Thank you. Good evening, Commissioners. My name is Megan Acevedo, and I'm the planner for W.C. Grace, LLC. W.C. Grace is applying for a conditional use permit and a special permit for their project located in the Willow Creek area on accessor parcel number 522-113-003. Here is an aerial image of the project location and its proximity to Willow Creek. The project is located northeast from Willow Creek. The project site is accessed from Highway 299 to Patterson Road, which is a county-maintained road, to Horse Lintow Road, which has been determined to be the equivalent of a road category 4 standard per the applicant's road evaluation report that was prepared by North Point Consulting Group. River Access Road is off of Horse Lintow Road to the project site, which is partially a private road and partially Forest Service road. The project has been referred to Six Rivers National Forest and received the standard comments for denial due to not being able to allow the transport of cannabis on federal lands. Although they received a recommendation of denial, this does not change the staff's recommendation of approval for the project. Here is the parcel for W.C. Grace LLC. Parcel size is 164 acres, zoned Timberland production zone with a land use designation of Timberland. They are applying for a conditional use permit for 17,300 square feet of existing outdoor light deprivation cannabis cultivation and 1,730 square feet for ancillary propagation. The existing and proposed locations for cultivation light deprivation greenhouses are shown in light green, and the ancillary propagation greenhouse is shown here in yellow. Water is sourced from a permitted groundwater well, which is shown with a blue starburst. The yearly water usage is 180,000 gallons, 9.4 gallons per square foot per year. The power source for the project is provided by 60% solar, which powers fans in the greenhouses and the water pump. And there is one generator that is used to power the drying and storage structure, which is shown here in orange. And the location for the generator is shown here in red. All processing will occur off-site. The applicant is also applying for a special permit to reduce the 600-foot setback to Six Rivers National Forest. The nearest cultivation area to Six Rivers National Forest is 239 feet away to the southern property line, and the setback is shown here with the green arrow. The recommendation for the project, we find the project is consistent with the mitigated negative declaration adopted for the CMM-LUO per CEQA guidelines. We recommend to make all the required findings for approval of the conditional use and special permit, and to adopt the resolution approving the conditional use permit and special permit subject to the conditions of approval in the staff report. That concludes my presentation, and myself and staff are available for any questions.
Thank you, Megan. Is there any questions from the commission for staff or Megan? Seeing none, I will open this up for public comment then. Oh, okay, sorry. Go ahead. Yeah. Mike Newman, go ahead and speak if you can.
Hey, I have to recuse myself again for this matter with the same reason, because of the applicants that are involved.
Okay, thank you. And we'll call you once again after.
Thank you.
Thanks. So with that, I'm going to open this up for public comment. It looks like we have one commenter so far. Kent Sawatsky. Go ahead, Kent.
So I always have to defer to Thomas Mulder on issues of cannabis, and maybe I misinterpreted what he said, but it kind of sounded like that last water usage and the amount of people were correct, but other permits that size have been for half that. So that just kind of leads me to question some of the other things. Cliff, just so you know, I'm not pulling these off of public notifications. I'm pulling these off of your agenda, which was published Friday. And so when you don't have accurate things on your agenda, which was published Friday, something's wrong with what staff's doing here. I mean, we have to rely upon that, and we have all these other things. And so I find that very disturbing. So according to what I'm pulling off the agenda, which I pulled off the side a little while ago, was 60% of the project electrical needs, as well as 3 generators housed within 3 structures. We were just talking about 1 generator. So what is it? That's my question. How, it just befuddles me that we can't get accurate, smart little executive summaries that are accurate or not. So maybe I misunderstood what you said, and if I did, I apologize. This is obviously admitted by your staff that it was an objection by federal people. You're having a setback to public lands. The feds object to this project, and so they have not assessed any negative impacts that you might be having on these federal lands, because obviously it's a catch-22 because they can't. So I don't know what extra things have gone to protect that particular public land. You're going over their objections as far as crossing the land. And so what is the setback reduction on this thing? How close is it to federal land? I had one in an area against mine where they'd actually cut a few trees down on federal property, and yet they could not make comments regarding it because of the constraints. So I did wish to really reach out to Scott Bauer for having participated and taking the time. That's really important to me, to have those concerns addressed, and that's what should happen every time you have constraints, is that if you can get someone to speak to alleviate my concerns and the concerns from the environmental community, that those things have been addressed. That's a wonderful thing. Regarding CEQA issues on this, Melanie, my understanding, and correct me if I'm wrong, but if it has less consequences than was brought forward in an EIR or something, has less negative impacts, you guys have always said, well, that's cool. There's no problem with CEQA there. It's when you cross the other line. So on a prior project, I didn't understand your logic there whatsoever. We have only 2,800 gallons of water storage, and we have a well that provides water for irrigation. I will continue to ask for, and all I can do is ask. I'll be happy to wrap it up. All I can continue to do is ask for these things, and I appreciate the applicants voluntarily doing what's right and fair regarding the environment and all these topics. So greatly appreciated for those people doing the right thing. Thank you.
Thank you, Kent. Any other public comment on this? Seeing none, I will close the public comment and bring it back to the commission for discussion. Anybody have any questions, any comments? Anybody want to make a motion? Don't everybody jump at once. Okay. the applicant wants? Raj? Okay.
Just about to jump in with a motion.
Raj,
Oh,
hold on a second, Noah. Praj, are you there?
I am here, Alan.
You came up late. Are you speaking on behalf of the applicant?
I am on behalf
Okay.
of the applicant.
I'll give you, make it quick.
Okay. I just wanted to, again, thank you guys all for participating. Listen to the comments and just wanted to clarify that the operations when it comes to different generators, the issue is that this project houses generally one larger generator, and then it has two very small generators, two 2200 size and 3000 watt, which are like whisper watt generators. And the idea is that when an operation is moving, you don't always need a larger generator. So having a second very small mobile generator is valuable. And then the third one is just a backup. So in this case, there are not three generators running. And recognizing the mode of sticking to fossil fuels and getting off of that, I spoke with the applicant, and the applicant is willing to move towards PG&E. Again, the concept here is that it takes time to get that done. But if that is the pleasure of the commission, I wanted to let you know that the applicant is going to be willing to accept a condition of 2 to 3 years to be able to get PG&E to this site and get off of the generators entirely. And if there's further discussion about any of the setbacks, I would like to have an opportunity to discuss that if it comes up. So I'm here and available to answer any questions. Thank you.
Sorry.
Yeah, I was.
There it goes. Didn't want to unmute. I'm sorry. So, any other questions for Praj while he's there? Seeing none, I will close the public comment and bring it back to the commission. And no, I think you were starting to make a motion before, so I'll put it in your court.
Yeah, I was starting to make a motion. I don't personally feel inclined to attach any additional conditions other than that's what's recommended in the staff report and any supplementals. I'm open to it if other commissioners want to discuss that. But for now, I will move that the commission has considered the addendum to the mitigated negative declaration adopted for the commercial medical marijuana land use ordinance pursuant to section 15164 of the state SEPA guidelines, make all the required findings for approval of the conditional use permit and special permit based on evidence in the staff report, and adopt the resolution approving the proposed WC Grace LLC project subject to the recommended conditions.
I'll second.
I'll second.
I think Ronnie was the first second, so we'll say she was. So any discussion on the motion in the second? Seeing none, I will ask Laura to ask the question.
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Brian Mitchell,
No.
and Melanie McGaver.
Yes.
Motion carries, I think it was 4 yeas, 1 no, and 1 abstention. All right, so that gets us to item number 8, which is, oh, excuse me, this one? Did I go one? Yes, I did. I apologize. Item number 5, wishful thinking. Calanola Incorporated conditional use permit in the Neeland area. We have a staff report. Please.
Would you like the other commissioner to rejoin?
Yes, we're trying to get him back on. Do you want to wait for him? Or? All right, he's back, so go ahead.
All right, good evening. My name is Cade McNamara, and I am presenting on behalf of Calanola Incorporated, who is seeking a conditional use permit, APN 314-193-004, within the Neeland area. Here is a vicinity map so that you guys can see this is within the vicinity of the Neeland Airport. This does not impact airport restrictions. This is where the parcel is located. It is accessed off of Mountain View Road and is self-certified to be of Category 4 road standards. The parcel size is 24 acres, zoned Timberland production, with a land use designation of Timberland. This conditional use permit encapsulates 13,460 square feet of existing cannabis cultivation, 9,400 square feet of which is existing mixed light, 4,060 square feet of which is existing outdoor. The project is supported by 1,920 square feet of propagation nursery space. Annual water usage is 142,500 gallons, which is approximately 10.6 gallons per square foot per year. Water is sourced from an off-stream rainwater catchment pond and a permitted well. Water storage consists of a 250,000 gallon rainwater catchment pond and 12,700 gallons of hard tank storage. Power is sourced from 6 generators. Each generator is muffled and held within enclosures, rated at no more than 57 decibels at 50 feet. We request that the condition for renewable energy source be within 2 years, to be finalized within 5 years. Processing is proposed on site. Processing will occur via a licensed third-party vendor until a permitted ADA compliant processing facility is permitted and constructed. Here we have a site plan where you can see cultivation area highlighted in green, water sourcing highlighted in blue, with the processing building highlighted in yellow. This black area here is the nursery space. Here we have sourced imagery from GIS of August of this year for the applicant's cultivation. I wanted to discuss a history of compliance. The applicant purchased this property after CDFW had commented on the project and has completed the request. They have changed from a diversionary water source to rain catchment and a permitted well. They have complied with Northern Spotted Owl protocol by muffling generators and keeping them within enclosures to mitigate noise and pollution, and also comply with international dark sky standards. We recommend and we find the project is consistent with the mitigated negative declaration adopted for the CMMLUO per CEQA guidelines, and make all required findings for approval of the conditional use permit. And that we adopt the resolution approving the conditional use permit subject to conditions of approval. Thank you for your time. Me and my colleagues are open to comment.
Any questions for staff on this one? Seeing none, I will open this up for public comment. I see 1, 2 hands up. Yeah, go ahead, you were first.
So again, I'm going off the agenda, and it says nothing about any kind of transition from generators. It sure be nice if staff would provide accurate information on the agenda, which I believe was put out last Friday. I wouldn't be pulling some of these things if we had accurate information. And it, quote, power is provided by 6 enclosed generators, period. Has nothing about a process to convert. Hopefully this conversion could be done, and it's kind of vague what's happening. Is it to be started, the conversion, in 2 years? And what does started mean? To be completed in 5 years? I think you want more definitive, anytime you have negative declarations and you have conditions, those should be definitive and with total understanding exactly what is expected from the public's viewpoint and from the applicant's viewpoint. This one, I applaud the fact that they are going to rain catchment. You have a pond again. I didn't know whether, again, it doesn't say here whether any kind of mitigation regarding that pond is, regarding bullfrogs or any other kind of things of that nature. And again, you know, people keep saying the goalposts keep getting moved, but I think the goalposts are just being defined. You know, this is referred to by the supervisor as building a plane while you're flying it, and therefore goalposts and even the values of public change with times as these things move forward. And I'm just asking for voluntary compliance. I mean, you know, and a lot of times I was a little distressed last time on your motion. The person volunteered to do a better thing, but the maker of the motion there didn't accept that volunteer thing and went with not accepting that. So I really would appreciate in the future if you'd accept someone who's doing the right thing, acknowledge that, and make that a condition. So thank you for my opportunity to speak on that.
Thank you, Kent. Scott Bauer.
Thank you, Chairman Bongio. I ask that you waive the 3 minutes if possible. I have quite a few comments to address on the staff report, if possible. Sure. I appreciate that. Our main concern is the cultivation area verification. Now, the applicant is applying for approximately 13,000 square feet. You know, we've been to that site. I was there in 2012. One of my staff was there in 2015. You know, we saw about 8,200 square feet. We actually received the Lake and Streambed Alteration Agreement back in 2015 that also said there was 8,200 square feet of cultivation area. So the staff report says that, you know, we commented that, this is a quote, we do not, that CF&W does not believe there was mixed light cultivation or that there was 13,460 square feet. It's not a belief issue, it's a factual issue. There wasn't pre-existing 13,000 square feet. So that's an important thing for you guys to consider when you make your decision. We also never observed lights, and lights, the reason we're talking about mixed light here is because I believe the consultant said he saw some in 2015. There's no photographic evidence that we've seen that verifies there was mixed light cultivation. So we would consider mixed light in this area to be a new activity, as well as the approximately 6,000 square feet of cultivation that we didn't see. We see those as new activities that don't really follow or doesn't, you know, go with the MND and the ordinance. You know, there's also a part in the staff report that says, you know, spotted owl activity centers are within a mile of the cultivation site. They're actually 0.4 of a mile. You know, it's just a little misleading to say, you know, it kind of makes you think maybe they're a mile away, but they're actually, you know, considerably closer than that. We requested NSO surveys back in, I think, 2018. So to say that our requests were completed by following dark sky standards and attenuating noise, it's not really what we asked for, albeit it's fine. But I just want to clarify that our requests back in 2018, and maybe it was even 2019, where we commented, we asked for, we brought up the fact that we want NSO surveys and some other things. So just pointing those out. The nursery also, if you consider the size of the nursery, it's about a 50-foot by 40-foot greenhouse. We support, 13,000 square feet. It's a pretty substantial size nursery. And in addition, there's a proposed 1,800 square foot 2-story building. You're putting approximately 3,800 square feet of additional, facilities on a TPZ parcel, and I believe it is allowed, but just to give you an idea, that we would consider that, new construction, new activities on this parcel. So, I'd make a request that the project be approved for 8,200 square feet. And that's basically our concerns, is really this cultivation area verification and what we saw and what we understand to have actually been there as CEQA baseline. So I'm available to answer any questions if you like. Thank you.
Any questions for Scott while he's right there?
Would you like staff to address the question raised through public comment?
Yes, staff can. I didn't see any.
I would.
Okay, so first off, for the first gentleman, as far as transitioning to renewable energy, within my comments, I had made, it was a request that the motion be included within this meeting. The applicant reached out and requested it for this meeting. As for the pond, there is a bullfrog management plan where there would be monitoring of frogs and annual drainage of the pond, and the pond is fitted with wildlife escape ramps. As for Mr. Bauer, I would like to say that the spotted owl references are all well over 2 decades old, though that does not diminish the comment made by Mr. Bauer. As far as the cultivation area verification, if you'd like, I can share my screen once more to show you what we have on file. This determination is what I take when drafting staff reports with fellow staff. Lastly, as far as these comments are concerned, Mr. Gresham, who is the applicant that we are discussing, purchased the property in 2018 and has done an amazing job to try and become compliant. And as we discussed, this is a 1.0 project. Generator use is allowed, and he is trying his best to be able to conform to the requests of all of the agencies. These agencies are allowed comment, and the county and its staff determines the outcome of what we include in our staff report by taking into account these agencies. And it is based off of our findings that we come forward with these presentations. Lastly, I would just like to really show you the CAV that we are basing our determinations off of. If you'd like, I can share my screen.
Go ahead.
All right, can you see this? So this is a cultivation area verification that was taken in...
Not yet.
I'm not seeing any.
It's not on there.
Oh, sorry.
There we go. Coming up.
All right. All right, so this is the cultivation area verification that was taken in October 26th of 2015 by LACO. The verification was made on November of 2017. And what we can see here are that there are greenhouses with outdoor next to it. and another greenhouse with outdoor next to it. As far as providing additional information to show whether or not this is mixed light or not, it is nearly impossible for someone who purchases the property under the intention that this is mixed light to have documentation showing whether or not this is mixed light. As far as comment goes, we also have comment from Chris Carroll, and I'm not sure if the agent and applicant are within this meeting, who would like to make comment stating that there may or may not have been mixed light. As far as things go with this being a 1.0, it makes things very ambiguous. That precedes my comment. If staff would like to comment to address other concerns raised, I'd be happy to hear it.
So any questions for staff? No. Seeing none, I'm going to go back. We still have.
I actually wanted to make one additional comment. So for the proposed processing facility, there are currently 3 trailers on site that are being used for processing. So processing is not a new use on the site. Processing has been occurring on site for the history of this project. There are 3 trailers that are on site, of which we have conditioned to be removed in place of this proposed processing facility that would also house living conditions for workers, and it would be ADA compliant, which I find to be environmentally sustainable.
Thank you. So we're going to continue with the public comment. There was one last person who had their hand up. So Nathan Whittington, please.
Good evening, commissioners and planning commission staff. Thank you all for staying so late to work through these. I'm sitting here with Mr. Gresham, and I'm the consultant and agent for this project. And I just want to highlight a lot of the concerns that Kate and Mr. Bauer brought up, and the steps we've taken in resolution, and reinforce that this is a great project that should be moving forward. Mr. Gresham purchased the property in 2018 after conferring with county staff and looking at the historical pre-existing determination that was done by LACO, and the staff told that Mr. Gresham that we'd be moving forward with this under the 13,460 square feet, with 9,400 of that as mixed light. As you can see in the CAV document, that clearly shows greenhouses. Greenhouses have generally been used for light depth and mixed light uses. My understanding from speaking with Mr. Chris Carroll at Timberland Resource Consultants, he was on site in summer of 2015, and in regards to a less than 3 acre conversion that was done. And he told me that he saw generators and some string light usage out there. Now, the generators themselves are 2,000 watt, whisper watt Honda generators that produce very little noise. Obviously that's allowed under 1.0, but we thought it would be prudent to take the extra steps to help this move forward and transition to renewable energy sources. And that plan will be developed and implemented within 2 years and completed within 5 years. In regards to the new construction of a building for processing and housing, there are trailers on site. We do know that we don't want trailers to be used as the primary source for building in these areas because of the potential for spillage and other environmental hazards that can happen there. And so the applicant has proposed the new building, removing those trailers, developing a leach field and appropriate septic system with an ADA compliant bathroom. It should be noted that the site was reconfigured after Mr. Gresham took it to increase the setbacks from the streamside management areas and ensure that the buffers were adequate for this kind of project. Talking about the pond and bullfrog mitigation measures. We have adopted all the CDFW mitigation measures and implemented those into our plan, and it's also outlined in the Water Resource Protection Plan. It should be noted that CDFW was on site in September of 2015, and this was at the point that winterization had occurred, and the original applicant, Mr. Miller, had removed the lights and generators so as not to cause any winter potential spillage of gasoline or anything else. The final point I want to make is that Humboldt County Planning Department is the lead agency for these projects. What they bring before the Planning Commission is the scope and determination of what we need to consider under a CEQA baseline analysis. They found that the LACO analysis on the CAV was correct and appropriate. And we should remember that when CEQA looks at baseline, they look at the entire county. And our county's done a great job through abatements and enforcement to reduce many illegal growths and through the permitting process to provide an appropriate path forward in an environmentally sustainable way. I'm available to answer any questions. Thank you for your time.
Any questions of the commission for Mr. Whittington? Seeing none, I'll move on to next caller, which is 707-273-3053.
Good evening, Thomas Mulder again. Sorry, I lost connection a little bit earlier. Can you hear me?
Yes.
So I'm gonna beat this drum, I guess, again. Ordinance 1.0 allows generator use as long as you're 50 decibels at 100 feet or against the habitat. So there's no restrictions on use of generators, how many hours, or any of those kind of things in the ordinance. So I want to remind you that as you're continually adding other mitigations and conditions of approval on projects. With those added conditions, you also need to remember that's added staff time. And unless the Board of Supervisors creates more staffing to deal with those post-approval things, it's continually overburdening the planning department. And as you guys can see, the Planning Commission, you aren't even going to get through your agenda with everything getting pulled over these generators. I think it's time that we draw a line and generators are allowed and we move forward on that. As also with generator use, I believe it's my understanding as long as it's under 50 horsepower, someone could have a residence with a 50 horsepower generator running 24/7 with no regulations, no anything. So if we talk about generator use, let's talk about it as a whole. As far as the CAV, I support the county with their CAV. I think this property, it sounds from listening to what I heard, that someone bought this property and is going to clean it up. This could have been an abandoned environmental hazard, but someone bought this property with the intention of X amount of square feet. And if the county did grant that CAV, I think you should honor that. And also the last thing is it sounds like it may be intelligent for people with TPZ parcels to start going through with moving forward with a THP or NTMP, so that way they have years of NSO studies to move forward with projects as well. Thank you for the opportunity to speak.
Thank you. Any other public speakers that wish to comment? Seeing none, I will close it and bring it back, public comment, and bring it back to the panel, to the commission. So, Ronnie, you have your hand up.
Yeah, I think it was still up from before, but
I
did. I guess the only thing I want to say is that, it's puts us in a hard position because there's such a big discrepancy between the two agencies as far as the 5,260 square foot difference in the CAV. But as I think was just mentioned, I think it's important that, we do honor what our staff has put forward as well. and they're willing to sign their name to it as far as the 2015 and 2017 cabs. And I think that's probably what we should honor.
Any other comments?
No. I agree with Ronnie there on that.
Well, we're running out of time, so anybody care to make a motion on this one? Get rolling.
Through the chair, if I could just interrupt, I apologize, but I know we're running out of time. If you do make a motion, I just want to be clear that the condition to transition away from generators into renewable power within 2 years or after 2 years is not in the staff report. And so if that's something, I did hear that the applicant's willing to consider that, but I believe that would need to be a part of your motion if that's something the commission wants to consider.
Thank you. Any other comments? Anybody care to make a motion? Come on, guys.
Sure. I will move that we find that we have considered the addendum to the mitigated negative declaration adopted for the commercial medical marijuana land use ordinance pursuant to section 15164 of the state CEQA guidelines, that we make all the required findings for approval of the conditional use permit based on evidence in the staff report, and adopt a resolution approving the proposed HUM FDC investment. Sorry, is that am I on the wrong one? Shoot. That we the Calinola.
Yes.
Yeah. The Calinola project, subject to the recommended conditions, with the additional condition I proposed based on the agent's offer, that they make a commitment to transition to carbon neutral power within some period of time, I guess I want to be sensitive to what we've been discussing about the period of duration. So I think I heard within 3 years, completed within 5 years. That sounds reasonable.
2.
Second.
Start within 2, finish in 5, I believe.
Started in 2, finished in 5. Yes, that would be acceptable. I think the second would accept that.
Yep.
We have a motion and a second.
Yeah.
Any
Sorry.
discussion?
Did the director have some observation to?
At this point, no, I think that the motion's been made and that's good.
Yes, Noah was the motion, Laura, and Brian Mitchell was the second. So seeing any other comment? Seeing none, I will ask Laura to ask the question.
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Yes.
Melanie McCaver,
So the yes?
Yes.
Or no? No, thought
yes,
so.
thank you.
Motion carried unanimous. Okay, we're at 9:30, 9:29, and there's no way we're going to do the rest of this. So how, Director, would you like to move forward with these? I'm assuming we'll continue them till next.
At the pleasure of the commission, I would recommend that you continue item number 8, or that would be E8, and then G1, G2, and G1 and G2 to the meeting of January 7th, 2021. And I will also say that one of the things I would like to do at the next meeting is, if anything is pulled off consent, that before dealing with the consent calendar, that we work on the Humboldt Bay Area plan and the modification to the dispensaries ordinance, because this is the second meeting we've had these on the agenda and haven't been able to get to them.
All right, so we need to have a motion to continue to the January 7th meeting, item number E8, and then items number G1 and G2.
Also moved.
So moved. Second.
I'm not sure who the first was, but Ronnie was the second. Mike was the first, Ronnie was the second. Any discussion? Do we need to open this for public comment? No. Okay. So we have a motion and a second. Laura, roll call, please.
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Brian Mitchell?
Yes.
and Melanie McCaver.
Yes.
Thank you.
All right, motion carries. So do we need for the appointment of officers, does that to be continued also, or will I just come back up on that?
You should continue that.
All right, so we'll need also to have a motion for item number
Well,
5.
What about H1?
Yes, both, I'm sorry, H1 and
H1 is continued to a date uncertain on the count on the agenda.
Okay.
So that leaves item under new business, item I, the election of chair and vice chair, that needs to be continued to the next January 7th. Do I have a motion?
Also move. I'll move that.
Mike is the motion. Who would second that?
Second.
Noah seconds it. Call for the vote. Laura?
Alan Bongio,
Yes.
Ronnie Pellegrini,
Yes.
Noah Levy,
Yes.
Mike Newman,
Yes.
Brian Mitchell,
Yes.
Melanie McCaver.
Yes.
Thank you.
Motion carries. You guys will give me just a quick second before we adjourn. The director and myself were talking during the break, and I'd like to propose that we ask the director to come up with some wording, and we send a letter to the Board of Supervisors asking them to come up with a proof of access ordinance. So every one of these projects comes that has an issue with access that we're not dealing with it. I know that other counties do it. The director said that they did it where he came from. And I think it would solve a lot of problems and save us a lot of time in the future. So I'd like to see him come back with something to us if you are all in agreement. I'm sorry to keep you here longer.
Yeah. Thank you.
Great idea.
Yeah.
So this is to talk about access to a parcel for.
Yes, so that before a project could be brought to us, that there would have to be proof that there was appropriate legal access to the parcel. I'm not sure how to word it exactly, but that's probably, so that it does, we don't sit here and spend an hour debating whether, you know, the wording is right. It should be done before it ever comes to us. And if they can't decide on it, then it shouldn't come to us till it's resolved. So
yes, bring it forward.
Do we need a motion on that, or is that just giving you some direction? That's what I thought as well. With that, we will adjourn the meeting. Everybody have a wonderful holiday. Look forward to seeing you in January.
Merry Christmas, happy holidays. Happy New Year.
Brian has a
Everyone.
Just before we adjourn, I thought it might be appropriate just to wish a happy retirement to Steve Warner. I've been working with him for a really long time, and he's taken on a lot of really big projects. So I just want to say thank you to him and happy retirement.
Great, thank you.
Yeah.
I heartily join in thanking Steve for all his years of service to the county.
Yep, he certainly has.
Amen.
I gotta say, there were times in my earlier years before John Ford was with us when sometimes Steve Werner was the guy up there at the staff desk that just cut through it and answered the hard questions and so thank you, Steve.
Thank you. With that, we are adjourned. Good night,
All right.
everybody.
Good night.
Thank you.